pop your pussy like this. Shake your body, don't stop, don't miss. All you ladies pop your pussy like this. Shake your body, don't stop, don't miss. Just do it, 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 do it now. Lick it good, suck this just like you should. Right now, lick it good, suck this just like you should. My neck, my back, lick my pussy and my crack. My neck.
Dude, you just touched Christy Boner's hoo-hoo.
Shibby!
Low five. Yeah.
Let's get out of here.
Ladies pop your pussy like this. Shake your body, don't stop, don't miss. All you ladies pop your pussy like this. Shake your body, don't stop, don't miss. Just do it, 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 do it.
And away we go. Check it out. Oh my goodness, guys. We got a new thingamajiggy. Here it is. Here it is. Coming strong. Let's go. Let's go. Let's get the jump. Let's get the jump, people. Whew. I was going to go to sleep and I thought, fuck it. I saw this. I'm going to make a coffee and I'll stay up and I'll sleep later. So here we go. I'll go back to the beginning. Page 1. I came to see you guys in chat. Look at this. Brand new today. Who's with me? Who the fuck is here? Oh my God. What's up? What's up? You guys ready for this? Can you hear me good? Check, check. Let me check on my computer. Let me see. Oh, I fucking sound amazing. You guys, let's do this. Let's go. I'm going to just start reading. It's a new APPELLEE. State's brief of APPELLEE. Oh my God. I started reading. I was like, oh my God, this is new. This is new. I'm listening to myself in my ear. Got to turn this off. Mute, mute. Perfect. So what's up? Who's here? Let's go. I'm just going to play it. I'm just going to read it. All right. State's brief of APPELLEE. A lot of names, more names, 94 pages, but it's going to be hopefully, let's just do it. I got a fresh coffee. Nicole, keep an eye on chat because I can't see anything. I'm just going to read for you guys. No fucking around. Nothing. No shenanigans. This will be serial Shibby. I'm going to read. All right. The brief of the APPELLEE, State of Indiana. Statement of the issues. 1. Whether the admission of evidence seized from Allen's home constituted fundamental error. 2, whether the trial court properly admitted Allen's confessions. 3, whether the trial court properly excluded and admitted various pieces of evidence. 4, whether the trial court properly denied Allen's motion to correct error. Now, 1 second, I just got to turn some fans off. I'm so sorry. 1 second. And we're back. I had to turn all my fans off. So sorry. Forgot. On October 28, 2022, the state charged Richard Allen with 2 counts of felony murder. The information was amended on March the 22nd, 2024 to add 2 counts of murder. Following a jury trial between October 14th and November 11th, 2024, the jury found Allen guilty as charged. On December 20th, 2024, the trial court vacated the felony murder convictions and imposed consecutive 65-year sentences. I was running around. I'm so sorry. Oh my God. I ran to get my coffee and everything. Sorry. Actually, 1 second. Oh my God. I gotta open the window. It's stuffy. 1 second. There we go. So, following a jury trial between October 14th and November 11th, 2024, the jury found Allen guilty as charged. On December 20th, 2024, the trial court vacated the felony murder convictions and imposed consecutive 65-year sentences on Allen's 2 murder convictions. Oh my God, I was running all over the place. Allen filed a motion to correct error on January 20th, 2025, to which the state timely responded. The trial court denied the motion. Allen filed his notice of appeal on March 11th, 2025, the docket. Now, I'm just going to catch my breath. 1 second, okay, guys? I'm going to grab a drink. Sorry. I'm right here. All right. Hey, Peggy, what's up? You guys see this? Oh my God. Fresh off the dock here, fresh off the press. So, statement of the facts. On the afternoon of Monday, February 13th, 2017, Allen killed 14-year-old Libby and 13-year-old Abby in a remote wooded area north of the Monon High Bridge Trail in Delphi. The Monon High Bridge Trail spans from Freedom Bridge over the Hoosier Heartland Highway on the northwest side and ends at the Monon High Bridge to the southeast. The High Bridge, there's an addendum. Oh my God, see, look, I almost skipped these. I got to remember this. Look at the little one. What is that again? Footnotes. Proper Shibby is not going to overlook these. Look at this professional Shibby. Look at this. Professional Shibby with the highlight. Thick highlighter is going to come back. He's going to know where to get to. Close enough. Footnote number 1. Due to the voluminous pretrial and trial exhibits, the state refers to the documentary exhibits by exhibit volume and PDF page number. The conventional trial exhibits are referred to by exhibit number, letter, and timestamp if relevant. Conventional pretrial exhibits also contain a hearing date where needed for clarity. Exhibits tendered in connection with the Frank's motion and the motion to correct error are designated sub X. You guys ready for this? Oh my God, I'm so excited. Shit. The Monon High Bridge Trail spans from Freedom Bridge over the Hoosier Heartland Highway on the northwest. Oh, I did kind of read a bit of this, but I got to the second one. I realized I skipped the first one. Sorry. The High Bridge to the southeast. Addendum 2. Oh, footnote. Exhibit 6 is drone video of the current day trial, which with vast improvements to the trail and, did I say trial? I said with the current day trail, with vast improvements to the trail and the first section of the High Bridge. Oh, this is already exciting. The High Bridge is an abandoned, dilapidated railroad track that spans 852 feet and is 65 feet high over Deer Creek. Lots of numbers, letters too. What are those Greek ones called again? Roman numerals, whatever. Wooden platforms extending out from the sides of the track occur periodically along the bridge. Platforms. There's 6 of them, 3 on each side. There was. The first platform was approximately 50 feet out from the start of the bridge. Numbers, letters. The trail dead ends at the far side of the bridge, where both sides slope sharply downhill. Parking to access the trail is located both near Freedom Bridge and farther east, at a side entrance on County Road. Did I skip a footnote? Nope. Road 300 North, known as the Mears entrance, because these are the ones I read, right? Yes. Ignore me. Ignore my excitement, my schoolboy excitement. Young Shibby's back. What's up, guys? You ready for this? Let's do it. It takes about 10 minutes to walk the trail from bridge to bridge. On February 13th, 2017, Delphi schools were closed and the weather was unseasonably warm. Nicole, can you give me a thumbs up? You guys can see and hear everything good, and I'll just carry on. Anybody? A good big yellow thumb or white, whatever color thumb you want. Delphi High School sophomores Brianne Wilbur and Riley Voorhees both saw 2 different guys. Nobody could point anybody in the court. Right on. Thank you, Mimi. Along with Voorhees, 2 younger sisters arrived at the Monon High Bridge Trail around 12:25 p.m. By 12:43 p.m., the group had walked from Freedom Bridge to High Bridge. Alan, who lived in Delphi and was familiar with the area, also went to the trail that afternoon. Surveillance video captured Alan's black 2016 Ford Focus driving westbound on CR 300 North toward the Freedom Bridge side at 1:27 p.m. He parked at the old CPS building and walked onto the trail. On their return, as they neared Freedom Bridge about 1:30 p.m., the group of girls encountered Alan as he walked in the opposite direction toward High Bridge. Alan noticed the girls as he walked past them without speaking. Neither Voorhees nor Wilbur saw another man on the trail who looked like him. After reaching High Bridge, Alan walked out to the first platform to look at fish, play with the stock ticker. Betsy Blair also went to the trail that afternoon to walk, to do a couple laps, to leave and go to potty, and then surveillance video showed her car driving eastbound on 300 North at 1:46 p.m. She parked at the Mears entrance and entered the trail there. Just before 1:49, Libby's older sister, Kelsey, dropped Libby and Abby off at the Mears entrance of the trail. Both girls were familiar with the trail. Libby's father, Derek, planned to pick them up later that afternoon. As the two walked toward the High Bridge, Libby sent a Snapchat message to Wilbur asking if she was still at the High Bridge. Wilbur responded that they had left about 10 minutes earlier. When Blair reached the High Bridge around 2 p.m., she saw a man, now known to be Alan, standing on the first platform of the bridge. As Blair circled back to the Mears entrance, she passed by Libby and Abby as they walked towards High Bridge. Blair did not see anyone else on the trail. Libby and Abby proceeded on to High Bridge and walked toward the southeast end. Libby took a photo of Abby on the bridge at 2:07 p.m. At 2:13 p.m., Libby took a 43-second video from the far end of the bridge, showing Abby cautiously walking toward Libby and a man initially denominated Bridge Guy by police, now known to be Alan, following behind her. Bridge Guy wore a blue jacket, blue jeans, a brown hat or hood on his head, and sneakers or boots. he had footwear. The audio captured the following. He says, "Is he right there? Is he right there?" Abby again. "Don't leave me up here." Libby. "See, this is the path." Libby's. That whispering. "That is a gun." Libby also. "There's no path here. We have to go down here." And then Alan says, "Guys." And Libby's, "Hi." Alan. "Down the hill." That was a little weird, because they didn't have to put Libby. They could have just let her say all this. But I'll do that properly again some other day. 7 seconds after the video ended, either Libby or Abby tried unsuccessfully to biometrically unlock the cell phone. Libby's Apple Health app captured the girls' movements. Alan brought the girls down the steep incline towards Deer Creek, where he later confessed he intended to rape them. Between Highbridge and Deer Creek was a single dirt driveway at the end of County Road 625 West that led to the Weber property. Alan saw a van, Brad Weber, driving home from work along that driveway, which scared him and changed his plans. Alan ordered the girls to cross the 100-foot wide creek. At some point, Alan ordered the girls to undress, and various pieces of the girls' clothing were discarded in the creek. Libby's tie-dyed shirt and camisole, one of Libby's Nike tennis shoes, Abby's jeans and underwear, together but turned inside out. Abby's gray hooded sweatshirt. Whoever's blowing me up on Discord, you don't need to, please. I can't turn that notification off. And a sock. Alan took the girls north of the steep creek bed to a secluded valley area that was difficult to see from the creek, the steep hillside to the north, and the Weber property to the south. Libby was naked while Abby was clothed. Oh, those were not. Yes, Jamie. Yes. I'm reading it as it is. Okay, guys, I'm sorry. Ted, hey. Peggy, what's up, guys? 94 pages on no sleep. No, I was about to crash, and I was like, fuck it. Ted said to go live, so I'm going to do it for Ted and Peggy and Dee Dee and Jamie and Ja Rule. You guys, oh my God. I'm just going to read it as it is, guys. I'm dying to stop, but I'm not going to commentate. So Libby was naked while Abby was clothed, partially in her own clothing, but wearing Libby's wet jeans and Libby's sweatshirt. We'll have plenty of time afterwards to go through this, okay? So Abby's tennis shoes were wet and dirty, consistent with the creek bottom. And if I've missed any footnotes, let me know, guys. So I don't think, nope, there isn't any. So that's good. I forgot I should be paying attention for those little numbers. Alan cut both girls' necks with a box cutter. Abby sustained one partial transection of her left exterior jugular vein. Libby sustained at least 3 separate injuries. A partial transection of her right common carotid artery. Oh, I said it right. I usually screw it up until I realize how I'm supposed to say it. Carotid artery. And complete transections of both her left common artery and her exterior jugular vein. Alan placed tree branches and sticks on their bodies. Did the appellate lawyers write this? Or is this from Nick? This is probably the response from Nick. I don't even know. Is this Nick? Should I be doing Nick's voice? Peggy, help now. Oh my God, is this in Cleveland? Or is appellee mean the prosecution? I should be reading as Nick. Oh my God, guys. I'm going to stop here until I get some votes to put if it's Nick or the defense. Guys, I'm freaking out. I should have been reading this as Nick. I'm not going to go back, but oh my God. Help me, guys. Help me. Is this Nick? This is, oh my God. Libby, I haven't done it in so long, guys. Forgive me. I'll make up for it, and I won't turn this into a mockery. But I need to do Nick's voice, right? Libby, how did I used to do that? Libby, cell phone registered, no movement after 2:32 p.m. Sorry, this is Nick McClellan now, and I'm taking over for Shibby because he's an idiot. At 3:11 p.m., Libby was not answering phone calls from her father. Derek walked to the Freedom Bridge trailhead where he encountered Dave McCain coming from the High Bridge side. McCain had not seen the two girls. Derek alerted family that the girls were not at the trailhead and that Libby was not answering her phone. Family quickly assembled and searched the Monon High Bridge Trail and in Delphi. Does this sound good old boy pretentious enough? I'm not making light of this, but I believe this is how Nick really sounds. As he left the scene, Alan kept off the trail to avoid being seen. Right. Yeah, you wanted to avoid being seen as he walked down the middle of the fucking road. About 4 p.m., Sarah Carbaugh saw a man, now known to be Alan. That should have been obvious when it was saying now known to be Alan. I was like, who's writing that? Sorry, guys. At least I realized it, so it's not too late. Stop blowing me up on Discord, whoever that is. Walking along the north side of CR 300 North as she was driving eastbound. He was hunched forward with his hands in his pockets, much like on Libby's video. Now, I'm going to take a note to a quick break. This better be good. Whoever's been blowing me up on Discord, I'm checking. It's better be good. Who is it? I'm gonna out you. Oh, I won't out you. Hey, I listen to you often. If I didn't, I don't have you blocked in a chat, and you have. I don't have what? Oh, you're just kidding, right? I don't have you blocked. What? Mar R thinks I have her blocked. What? I don't have you blocked. Silly. What? You guys, Nicole, who talk to Mar R because I don't have her blocked, so I don't have anyone blocked. There's one person, but somebody contact Mar R on Discord if you can. Whoever talks to her, and tell her that if she may have accidentally blocked me a long time ago, there's two types of blocking: hiding and blocking. So, can you do that? I don't have her blocked. Come on, she's blowing me up. Whoever that is, stop! I can't turn the damn notifications on. I'm going to keep reading. I don't have her blocked. I would never block her. Come on, she's sweet. As he left the scene, Alan kept off the trail to avoid. Yeah, this is the dumb part where he walked down the middle of the road. Walking along, where did I stop? He was hunched forward with his hands in his pockets, much like on Libby's video. She noted that he was covered in mud and had fresh blood splatters on his light-colored jeans. Around 5 p.m., law enforcement and Abby's mother were notified that the girls were missing. Search teams scoured the trail and spent 22 hours looking at a small area and couldn't find them, and areas near the High Bridge until 2 a.m., when the search was called off for no good reason the night. Law enforcement also checked in with Brad Weber, who allowed a deputy to look around his property for the girls. What? That was it was later on. The search resumed the next morning, February 14th. About noon, searchers along the south side of Deer Creek found some of the girls' clothing tangled. I should have realized when it said girls', because I don't know, that just feels weird. The girls', why can't we say of the girls' clothing tangled in branches in the water? Searchers were directed to the north side of the creek. Access was made by going down the steep hill that ran south of the cemetery on 300 North. The girls' bodies were discovered behind mature trees north of the creek. Blood pooling on the ground, blood transfer patterns, and DNA testing indicated that Libby's injuries were inflicted next to a small tree to the west of the girls' bodies. After touching the tree with her bloody hand and or arm and creating an inverted L shape in blood, Libby walked toward Abby and sat or kneeled on the ground, where she either fell unconscious or died in a large pool of blood. Alan then dragged Libby's body by her left arm to her final resting place behind a large tree. Although some of the blood flow on Abby's face suggested her head had been moved or turned, she was injured and died where she was found. Abby was already clothed when the fatal injury was inflicted. My goodness. Oh, my coffee's perfect. You guys having a good time? I'm going to read this seriously, but I'm using Nick's voice. I have to. Sorry. Would never, ever, 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 like make light of Abby and Libby. You guys know that, okay? This is totally Nick. Neither girl showed defensive wounds or outward signs of sexual assault. A small amount of male DNA, perhaps simply from environmental factors, was detected in the external genital swabs of both Abby and Libby, and from fingernail scrapings from both girls, but it was an insufficient amount of DNA for analysis. Libby's cell phone and her other tennis shoe were discovered underneath Abby's body. The video of their kidnapping was found on the phone. The phone had condensation and moisture on the screen, had connected on and off from the cell tower all afternoon on the 13th. Yeah, all over town. But lost cell tower connection between 5:45 p.m. on the 13th and 4:33 a.m. on the 14th, when it momentarily reconnected before it powered off. An unfired Winchester brand .40 caliber cartridge was found in the leaves between the girls' bodies. Did Mar get in here yet? Because I don't have her blocked, so if she can't get here, what? I feel weird now. I don't have Mar blocked. I go through my block list constantly because see, like any of the mods are blocking people, and every now and then I see trolls' names. Mar's not in my list of blocks or anything on both of them, on Google or YouTube. So I don't know what she's saying. Someone talk to her, tell her to get her butt in here. Later, ballistic testing showed that the cartridge had been cycled through Allen's 6-hour P226 .40 caliber handgun. On February 14, 2017, Voorhees, Wilbur, and Blair, so Riley Voorhees, Brianne Wilbur, and Betsy Blair, told police about seeing 3 different guys. One, Voorhees said it was all black, dressed in black, and black boots and black mask and hair sticking out and a squared off jaw with a, oh my goodness. Wilbur described someone different. Betsy Blair described a poofy-haired guy, and they insist it's the same guy. Okay. Told police about seeing a man on the trail platform the previous afternoon, and after seeing the bridge guy photograph from Libby's phone that was released to the media, they immediately identified Bridge Guy as the man they had seen that day. Carbaugh also came forward a few weeks after seeing the picture of the Bridge Guy and identified him as the muddy and bloody man she had seen on the road on February 13th. On February 16th, 2017, Allen reported to police that he was on the trail on February 13th between 1:30 p.m. and 3:30 p.m. and walked past a group of 3 girls as he entered the trail near Freedom Bridge and walked to High Bridge. Ooh, lots of numbers. Allen said that he saw no one else on the trail. Allen's report was misfiled under Richard Allen Whiteman. Totally fooled the state-of-the-art Orion tip system. Totally fooled it. And mistakenly marked cleared. In September 2022, Allen's report was discovered in a box. And on September 21st, Kathy Shank's poor belated husband's dead Thursday. It shares with Shibby. And law enforcement began investigating him for the first time. 5 years later, they have the guy who came to them within 3 days. On October 13, 2022, Allen met with Detective Tony Liggett and investigator Stephen Moonman Mullen. I missed saying that. Allen confirmed that he walked to High Bridge on February 13, 2017, saw 3 girls, one older and 2 similar-looking younger ones. Two similar-looking younger ones who were possibly sisters. As he entered the trailhead and then went out to the first platform on High Bridge to watch the fish. Allen now claimed that he was on the trail earlier from 12 p.m. to 1:30 p.m. Ooh, look at all these numbers. What does this mean? Oh, this is probably in, I know this means it's in like some statement or video or, his interrogation or whatever, interviews. That's like the timestamps, probably. He said that he probably was driving his 2016 black Ford Focus. Allen said he did not see anyone else on the trail that day, specifically not Bridge Guy. Allen said he was probably wearing a dark Carhartt jacket with a hood. Yeah, like they asked him, could you have been wearing this? He could, yeah, I could have been, I guess. And they turn it into the yeah. So don't talk to police, kids, ever. Blue jeans, either tennis shoes or work boots, and had a hat with him. He indicated that he might still have his cell phone from 2017. I do. When I have one from 2014, my iPhone 4, I kept them, I collect them. When confronted with the picture of Bridge Guy, Allen stated that if it was taken with the girls' phone, there's no way it could be me. Well, you got him. And I didn't lend my gun to anyone. A gun that was never used. How's everybody? We're doing good? Doing good. I got the scoop. I should keep reading. Officers recovered Allen's Sig Sauer model P226 40 cal handgun, blazer 40 cal ammunition, one unfired Winchester brand 40 cal cartridge in a keepsake box, a blue Carhartt jacket, several knives and box cutters, and photos showing Allen on the high bridge in 2016 nonetheless. Allen still owned his 2016 black Ford Focus. Although Allen had 12 other old cell phones in the master bedroom closet. Allen's cell phone from 2017 was not found. Allen told ISP Lieutenant Dick Jerry Holman more than once during the search, "It's over. Yeah, his life is ruined. You're trampling on his front lawn with the media. All his old ladies are looking out their front doors, rubbernecking. And you got fucking people walking out his front door carrying, they know why you were there. His life was over. Even if they retracted a 1,000,000% innocent, we got the wrong guy the next morning in the front page of every paper in all of the USA, those people would still, his life was over at that point." Allen gave a second interview on October 22nd, 2022. Allen said that he did not have his handgun with him at the trail on February 13th, 2017, and denied loaning it to anyone else. If he carried it, he would have a handgun in a side holster and a round chambered. Allen had no explanation for how a cartridge cycled through his handgun could have ended up at the scene, and denied the possibility that any cartridge at the scene could have come from his gun. Now, the jurors all said they didn't go for this bullet. How is he still able to use this? You know, every juror said they didn't buy it, right? We know it. None of the jurors fell for the bullet shit. I know it. I just know it. This is such bunk. Tool mark. It's fucking, what a scam. It's not even ballistics now. It's tool mark. Anything harder that makes an imprint on something softer. This lady's an expert. Over. No wonder she's never wrong. It's her subjective opinion. How can you be wrong? It's her opinion. Look at trigger warnings all over this paper saying it's a subjective opinion, whatever they call that. The possibility that any cartridge at the scene could have come from his gun. Allen was arrested. In early November, following the filing of charges, the trial court ordered Allen to be transferred to the IDOC, the Department of Corrections, for safekeeping due to media and safety concerns. I'm just going to read, guys. I can't stop because that's for his safety, remember? Safekeeping. They tortured a fucking innocent until proven guilty citizen of the United States for his own safety. DOC placed Allen at Westville Correctional Facility in APOD, a single-man cell in the restrictive housing unit. The 12 by 8 cell had a bed, a toilet, a sink, a slot in the door through which his meals were served, and a narrow window for daylight. After Alan complained that the scratches in the window made it hard to see out, DOC replaced the window. Alan was given showers 3 per week, out of cell recreation time 5 times per week, 3 sets of clothing, and weekly laundry services, books and puzzles, and an electronic tablet that he could use to communicate with family, listen to music, download movies, and play games. When his first tablet broke, Alan did not have to pay the usual fee for a replacement tablet. Alan was offered a television for his cell, but declined it. Alan could dim the cell's overhead lights. Alan was granted in-person visits with his wife, which is generally not permitted or for restricted housing convicts. Oh, but he wasn't a convict. Isn't this like defamation? Because at the time, he's innocent until proven guilty. Isn't this defamation, calling him a convict before he's convicted? What is going on with the United States, you guys? I'm pissed. Alan had successfully access to weekly chaplain visits upon request and received regular checks by medical staff. Although shackled while being transported outside his cell, Alan's shackles were removed during his sessions with F.G. Walla. I refuse to say this in front of this. F.G. Fangirl Walla, the DOC fangirl, and his meetings with his wife and attorneys. Although placed in the same kind of physical environment as convicted offenders in that unit, Alan was treated better, and the primary goal was to keep him safe from himself and the general population. The administrative and medical team met to discuss how to make Alan more comfortable. DOC policy restricted periods of solitary confinement to persons with serious mental illnesses, SMI, to 30 days. But Alan's initial diagnosis of major depressive disorder and anxiety did not meet the definition of SMI. Because he entered WCF on Westville Correctional Facility on constant suicide watch with prior mental health diagnoses, the cell Alan was placed in was the suicide cell with 24-hour video monitoring, and he was observed by suicide companions, fellow convicts. Alan met with F.G. Walla daily, usually in a nearby room with a metal grate partition between them, and otherwise at his cell door. Alan was offered the opportunity to meet with F.G. Walla out of his cell at least once a week. During a session in early November, F.G. Walla advised Alan not to talk about his case with anyone. Except me, poor me. I'll be your friend, Richard. Tell me. Here, read this. Say this, Richard. Search this. And she did not ask him questions about it during their sessions. Baloney. By December 2022, Alan was removed from constant suicide watch and placed on close observation. He was observed every 15 minutes, and Alan met with F.G. Walla once a week. Alan did well in the first months of 2023 until we got him in solitary confinement on April 4th, 5th. We could really take him away from eyes, torture him. We got rid of his tablet. Yeah, we didn't get his mail. He had no fucking clue what was going on. That Wallace says that he didn't want to call Kathleen because he was mad. And the first thing he says to them is like, I didn't know what's going on. They wouldn't let me call you guys and all that. What fucking hogwash. Alan found Jesus and accepted God into his heart in late March of 2023. And because increasingly concerned with religious matters, what? They threw that in. That's new. Because they're saying this is like, so they're using his, but they've brought this up a bunch of times, but this feels new. Increasingly concerned with religious matters, like as if they can use that as a reason to like treat him differently, maybe. I don't know. Increasingly good. That feels weird. In late March and early April, Alan began receiving his legal discovery. and he had a visit with his attorneys on April 3rd or the 4th. In early April 3rd, 2023, corresponding with those events, Alan's mental health quickly deteriorated. Yeah, Alan started to refuse meals and act out. On April 3rd, Alan told his wife, "I did it. I killed Abby and Libby." The next day, F.G. Walla upgraded Alan back to constant suicide watch. Correctional officers were assigned to observe Alan, and F.G. Walla met with him every day. On April 5th, Alan confessed to F.G. Walla and in a written note to the warden that he had killed Libby and Abby. Well, there's so much I could say, but I'm going to just read it, guys. Footnote number 3. So remember that. Footnote number 3. Here it is. Although Warden Gallipo testified he was given the note on March 5th, the suicide companion's testimony and log and what bullshit, oh my God, and the DLC chain of custody form show Alan delivered the note on April 5th. So he lied and tried to say he got it in March. Fucking Gallipo lied. He tried to write March on it, I remember. And it was really April 5th, they say. So weird. April 5th is the day all those guards started, which is bullshit. I know it. I think all those confessions they allege and all that shit was said between April 5th and the 9th. I think it was said to those convict, the inmate suicide companions. And they had to lie and say all those guards showed up. Each one under even more suspicious circumstances. The guards are showing up. And it's just a bunch of hogwash. Like 5 of the guards in their testimonies. Yeah, I showed up, but my paperwork didn't have this on it. Or I filled this top piece out, he filled the middle, and I filled out the bottom. Every one of those guards, go back and read their testimony. There's 6 of them. The first guy, I remember the first guard, he got fired because he didn't want to toe the line. Then there was like 5 guards that all bullshitted and said they were there to correct on the 5th, 6th, 7th, and 8th before the 9th or whatever, when they turned his cell upside down. And they say Richard Allen threw all the shit all over his cell, all his discovery. They're lying, in my opinion. I guarantee it was to those suicide companion inmates, not the guards, in my personal opinion. Because each one of them, it's so goddamn suspicious. Their testimony, it's like 10 things, each one of those guards that make you sound like they're so full of shit that they weren't there. He told F.G. Walla he acted alone and his intentions were sexual in nature. I almost said it. F.G. Walla warned Alan again that it was not in his best interest to talk about this case. Yeah, she was so worried about him. I swear I'm going to try to read this, guys. 2 days later, on April 7th, Alan said that he killed Libby and Abby by himself and that he was just acting like he was crazy. On April the 8th, 9th, and 10th, Alan made statements that he killed the girls and expressed remorse. During the ensuing days, Alan's behavior became increasingly bizarre, including drinking toilet water, smearing feces on himself, and in his cell, and eating his own feces. Yeah, he was just trying. The guards implied that he was doing that just to get their attention, I'll just take a quick note. How's everything in chat? Everything good, guys? All right. I'm sorry if I'm missing you guys. I'm just going to keep reading, okay? And then we'll get talking to this. Alan shifted quickly back to normal behavior if he wanted something. Or he would have behaved outrageously to get attention. See, that's what they said. Fucking nerve of these people. As if he's manipulating them. They act like he's manipulating them. He's fucking in a cell, solitary confinement, being tased, fucking handcuffed, walked around with a leash, camcorder on his showers, everything. People yelling at him all night. They act like he's fucking manipulating them. Fucking assholes. Garbage humans. Every one of these people on the prosecution side. Every one of them. Every person in IDOC. Not one whistleblower in 395 days. You're all garbage humans. You'd rather a paycheck and you can just look away at an innocent man being tortured. You're fucking garbage. By April 13th, Alan's behavior was deemed severe enough to warrant medical intervention. The next day, Dr. Martin presented Alan's case to a treatment review committee, which agreed that Alan was exhibiting psychotic symptoms that warranted an involuntary injection of Haldol and antipsychotic medication. Psychosis ebbs and flows, and a person can slip in and out of psychosis in a 24-hour period. Oh my God. Alan was administered an injection of short-acting Haldol for 4 days, April 14th to the 17th, and monitored for side effects. He received long-acting Haldol injections on April the 18th, May the 18th, and June 16th. Between April the 14th and May the 2nd, Alan's psychotic symptoms slowly improved. Yeah, we had to get him ready for trial. He continued to confess during that period, including an admission on April the 29th that he had used a box cutter he stole from CVS to kill Abby and Libby. By May the 2nd and May the 3rd, he had returned to baseline and no longer exhibited any significant psychosis. Oh my God, they're even putting this in paper. This is absurd. Oh my God. Alan was diagnosed as having suffered a brief psychotic disorder with marked stressors. On May the 3rd, Alan gave his most detailed confession to the offenses to F.G. Waller. This was the first time he mentioned that seeing a van was what scared him. Oh, the first time he mentions it. Yeah. And caused him to forgo raping the girls. This new piece of information that a van had driven by, which only Bridge Guy would know, led investigators back to Brad Weber. Oh my God. You just reading this, it sounds, this is such hogwash. If this was the first time I read it, I would say, this sounds like garbage. If this was the first time hearing this stuff, I would think, this sounds ridiculous. Is this person lying? If I never knew anything about this, just this sentence here, led investigators back to Brad Weber. Weber's work records show that he clocked out of the Subaru plant in Lafayette at 2:02 p.m. on February 13th. Weber confirmed that he had driven his van to work that day and went straight home, which would have placed the van on his driveway near High Bridge and the creek shortly after the girls were kidnapped. Yeah, so 2:32, he's driving by. He's admitted being closer to the crime scene than Richard Allen has, because the girls, they said, were taken down the bridge. They were right on that road at that time, basically. And Brad Weber says he's right there. Richard Allen said he was on the first platform, which is like 400 feet away. Allen continued to confess many more times to F.G. Waller, watch companions, and his family through May and June, and even as late as February 2024. This is wild, eh, guys? Imagine you read this for the first time. You would be thinking, something doesn't sound right. This guy sounds like he's lying. This was the first time. And there was a bunch of calls. So yeah, as February, right? So, and even as late as February, calls from May, these dates, about 4 different dates, there were those phone calls to his mom and to his dad, I think, and to Kathy, audio calls. Additional facts will be provided as necessary to the issues. Summary of the argument. 1. Alan Frank's claim is waived in several respects, and it is meritless. Liggett did not include false statements or omit material information from the probable cause affidavit. I'm just going to keep reading, guys. And the affidavit still establishes probable cause, even if the challenged statements, omissions are included. Ooh, the fact that he's even saying that means he knows it. It's like, okay, fine, take out that bullshit they get put in. It's still good enough. It's almost what he's saying there. Whew. I'm surprised they'd even kind of admit that. Like, even kind of entertaining that means they know it's fucked up. 2. Alan's challenge to his confession is waived. Regardless, his confessions were voluntary. Oh my God. the requisite state coercion is absent, and the conditions of his confinement did not rise to the level necessary to constitute coercion. Oh my God. Allen also has not shown that the conditions caused his confessions, as the record provides other explanations for his desire to confess, and he confessed both before and after his period of psychosis. Allen's other state constitutional challenges are meritless. Allen's challenge to the exclusions of the IPAS settlement at the suppression hearing is moot, and he has not raised any challenge to its exclusion at trial. Regardless, Allen was allowed to present evidence of DOC policy regarding SMI prisoners in restricted housing, and any minimal probative value of the settlement agreement from an earlier unrelated lawsuit was outweighed by the danger of prejudice and confusion of the issues. Its exclusion is at most harmless error. The trial court, the trial court properly excluded inadmissible evidence. Blair's investigatory sketch of Bridge Guy was not relevant because she did not identify Allen. Oh, what? What? In court. What? Because she did not, her sketch was irrelevant because she did not identify Allen in the sketch or in court? What? This was their whole case, is that Betsy Blair saw Richard Allen on the bridge. What? Oh my God. Yeah. What is it important? Because it was I'll read it after this here. Allen, it was unduly prejudicial and it was inadmissible hearsay. Here we go. What's going on? I heard beeps and I kind of ignored it. There you go. Oh. Oh. Okay. I'm good. I'm good. Let's do this. Do you want to come on? Here. No, I'll read this and we'll talk about it after. I should just read this. Okay, guys? Tobin's testimony, and we'll do it. How about we'll plan a show to talk about this on your show tonight, Ted? Why don't we do that? Because I'll read this for the people, and then tonight, because I'm going to need to sleep eventually. I should have been sleeping, so I'll read this, and then we'll plan a show. Okay, Ted, and we'll break this down really good. We'll have anybody else if you want. I should just read this for the people, like, because they're all dying. Tobin's testimony was not relevant because it went to the admissibility of firearm. Tobin's? Who the fuck is Tobin? What is that? Tobin? Is that Oberg? Tobin's testimony was not relevant because it went to the inadmissibility of firearms. Identification. The guy. Okay, this must some guy, right? An expert. Evidence as a science, not to witness credibility. And firearm identification evidence is admissible in Indiana. The audio of Allen's movements video was hearsay. His 2 jail calls on April the 3rd, 2023 did not fall under the doctrine of completeness. Dr. Grazian's opinion that Allen's confessions were false was impermissible. Vouching evidence. Perlmutter's third-party motive testimony, opining this was a ritual killing, was properly excluded under Evidence Rule 403. It was impermissibly speculative. Can you use? I guess you can use it because you put a Y up. Can't overuse the same word. Speculative, unsupported by any odiness who could be connected to the crimes, and based on inaccurate or highly disputed contentions about the crime scene. Like, he's allowed to say odiness in this, but they couldn't bring it up at trial. Oh my God. Allen's proffered third-party suspects were unduly speculative and did not tend to show Allen had not committed the murders. Holder had a confirmed alibi, making it impossible for him to have committed the crimes. And Allen never contended that Westfall, whose sole alleged connection to the crimes was his odinism, could have committed the crimes by himself. Right. They have to reply to the appellate stuff, right? So I get it. It's 143. Any error in the exclusion of any of the evidence was harmless beyond a reasonable doubt based on the eyewitness testimony and Allen's statement placing himself at the scene, which combined to identify Allen as Bridge Guy, the presence of a .40 caliber cartridge cycled through his gun at the scene, and his numerous confessions. Excuse me, guys. Taking a drink. The admission of the Google search for an alternative theory explaining the cell phone's audio output code was harmless error. Oh, that was this Google search of Cecil. None of the theories for that code made it more or less likely that Allen killed the victims. 4. Rocky 4, I know that. The trial court properly denied Allen's motion to correct error. Allen did not show that the state offered demonstrably false testimony because he did not verify the date and timestamp on the surveillance video, nor did he establish a foundation for the FBI ping evidence. Allen had an adequate opportunity to impeach the witness with this evidence, but he strategically chose not to. Last, this evidence would not have impeached Allen's confessions to seeing the van. This court should affirm Allen's murder convictions. Argument 1. The court properly admitted evidence found pursuant to a valid warrant search of Allen's house. The search warrant for Allen's house validly established probable cause. Therefore, the court properly admitted evidence found in that search. The gun, a .40 caliber cartridge found in the bedroom, a blue Carhartt jacket, and knives. Footnote 4. The vast majority of Allen's first Frank's motions, memo, and all of the subsequent Frank's motions are addressed to arguments about the warrant affidavit's validity. That Allen has abandoned on appeal. The relevant portion of the Frank's memo asserting the argument raised on appeal is found at appendix lots of numbers. Because this appeal follows a completed trial, the issue is whether the evidence was properly admitted at trial, and the ruling is reviewed for an abuse of discretion. Sloan v. State precedents, trans denied, but to the extent admissibility turns on the constitutionality of a search uncovering the evidence, that question is reviewed de novo. Precedents Jacob v. State. A. Allen did not preserve this issue for appeal. Allen's Fourth Amendment challenge to the admission of this evidence suffers from multiple issue preservation problems. First, Allen waived this issue entirely by failing to object to this evidence at trial. A pretrial motion to suppress is insufficient to preserve an issue for appeal. Footnote number 5. The recent amendment to Evidence Rule 103B, which is not effective until July 1st, 2026, allowing preservation through pretrial rulings, was not in effect at the time of Allen's trial and is therefore inapplicable to this case. See the precedents listed there. When I see precedents, that's, they're listing like a court case from 10, 20, 50, 100 years ago as precedents, like as how it should. That's the only way we know how it's been done. So we should kind of do it the same. They state precedents. Here's another one. Precedents Brown v. State from Indiana in 2010. That's precedents. Example, to preserve a claim of error, the defendant must contemporaneously object to the admission of the challenged evidence at trial. ID. Allen did not object when the state elicited testimony pertaining to the search of his house and affirmatively stated that he had no objection to the admission of the gun and cartridge and to the photographs of the Carhartt jacket and knives. By failing to research his Fourth Amendment challenge at trial and instead stating that he had no objection when the evidence was proffered, Allen has waived appellate review of his challenge to the warrant. ID. See precedents Halliburton v. State in Indiana 2013. The precedent's example is stating that defendant may not affirmatively state at trial that he has no objection to the admission of evidence and then claim such admission to be erroneous on appeal. Allen, who does not acknowledge his waiver, makes no argument that the admission of this evidence constituted fundamental error. Appellant's brief 59 to 67. He has therefore waived any claim of fundamental error. See Curtis v. State precedents from Indiana in 2011. Moreover, Fourth Amendment issues generally are not subject to fundamental error review because they did not undermine guilt. Brown precedents, something, examples, something here, whatever that is, paper, I don't know. Fundamental error review is available only when a defendant claims fabrication of evidence or willful malfeasance by the investigating officers. ID. I guess that's example. There's no claim of fabricated evidence here, and Allen's assertion that Detective Liggett recklessly made false statements or material omissions is not a claim of willful malfeasance. Appellant's brief 64. Only deliberate lies or intentionally misleading omissions could constitute willful malfeasance. Footnote number 6. Boy, it's a long one. The only statements, omissions Allen claims showed more than reckless disregard for the truth are the two statements pertaining to a blue jacket. Appellant's brief 65. One of those statements, Allen's description of the clothes he was wearing, is not properly before this court at all, as will be argued below. That leaves only Carbaugh's description of the coat available for fundamental error review. Excising that sole statement from the affidavit does not undermine the existence of probable cause and thus the validity of the warrant, much less undermine the fundamental fairness of Allen's trial. Where's that little number 6? Where are you? Oh boy, where are you? There you are. Peekaboo. See www.merriam. Go read the dictionary. I'll prove it to you. Defining willful as done deliberately, intentional. For both of these reasons, go look it up in the dictionary yourself. For both of these reasons, Allen's waived Frank's challenge is also not subject to fundamental error review. Second, even if the entire issue were not waived, the fourth way in which Allen alleges the magistrate was misled, Allen's description of his clothing that day and his wife's confirmation that he owned a blue Carhartt. Appellant's brief 63 and 64. This is good. This is exciting. Is raised for the first time on appeal. So I'm reading as Nick McClellan, guys, so please don't think I'm making light of this. Allegations of error raised for the first time on appeal are waived. Washington v. State precedents a bunch of numbers from Indiana in 2004. An example is a trial court cannot be found to have erred as to an issue or argument that it never had an opportunity to consider. Example. And that means example, right? ID? I always thought it was EG, but I'm feeling it means example. And a defendant may not object on one ground at trial and then raise a different ground on appeal. Hauser v. State precedents from Indiana in 2005. Below, the only false statements or material omissions identified by Allen were Blair's description of Bridge Guy and her disagreement with the Carbaugh sketch. Blair's description of the car parked at the CPS building. That's all, eh? Your main witness. You ignored half of what she said. and Carbaugh's description of the man she saw walking. Yeah, she did. I'm just going to read. Sorry, guys. Appellate numbers. Allen did not identify Liggett's recitation of Allen's description of the clothes he was wearing and his wife's confirmation of his ownership of a blue Carhartt as false, misleading statements or omissions supporting his Frank's challenge. Appellate numbers. Rocky 4. Because Allen's reliance on these statements is an improper appellate attempt to supplement his Frank's challenge, this court should limit any consideration of this issue to only the first 3 ways that Allen contends the affidavit is misleading, as those were the only allegations the trial court had an opportunity to consider. See Daring v. State precedents from Indiana Court Appellate 2018. Finding alleged omissions from the affidavit waived because Daring did not raise them in the trial court and limiting our discussion to the omissions raised in Daring's memorandum to the trial court in support of his motion to suppress. Finally, to the extent Allen suggests that success on this issue results in suppression of his confessions, Appellate's Brief 66, that claim is doubly waived. First, although Allen challenged the admission of his confessions below on other grounds, he did not raise any Fourth Amendment challenge to their admissions or object on the basis that they were the fruit of an unlawful search. Appellant's numbers. More numbers. A defendant may not object on one ground at trial and then raise a different ground on appeal. Hauser, memorandum type of precedence, whatever. Because Allen did not object to admission of the statements on Fourth Amendment grounds in the trial court, he is precluded from challenging their admission on that basis for the first time on appeal. Second, Allen's bare assertion that his statements are a suppressible fruit of the search is unsupported by cogent argument. Appellant's Brief 66. All arguments must be supported by cogent reasoning and citation to authorities, and the failure to make a cogent argument waives a claim for appellate review. Indiana Appellate Rule. Super bunch of numbers, precedents. Miller v. Patel, Indiana 2023. To be a suppressible fruit of the search of the house, Allen's confessions must constitute evidence derivatively gained as a result of information learned during the search, rather than through a means sufficiently distinguishable as to be purged of any taint from the search. See McCollum v. State Precedents from Indiana Court Appeals 2010. Those precedents. This Allen does not explain how volunteered statements made to family, doctors, and correctional staff more than 5 months after the search of his house and after he had been advised of his rights, appointed counsel, and a court found probable cause to support his arrest could constitute a fruit of that search. CID. Example, I guess, listing as the relevant factors in this analysis the amount of time elapsed between the illegal search and the acquisition of the evidence at issue, the presence of intervening circumstances, and the purpose of a flagrancy of the official misconduct. It is not this court's province to develop an argument on Allen's behalf. See Miller, precedence example, Thomas v. State from 2012. By failing to present cogent argument on this point, Allen has waived any claim that his confessions are suppressible due to the alleged invalidity of the search warrant. B. Allen has not shown that probable cause for the search warrant was predicated on false statements or material omissions. Waiver notwithstanding, Allen has not established a Frank's violation. Probable cause exists to issue a warrant when the totality of the circumstances set forth in the affidavit demonstrates a fair probability that evidence of a crime will be found in the location. Illinois v. Gates precedents from 1983 and daring precedents from whenever. Search warrants are presumptively valid, and in assessing whether an affidavit established probable cause, doubtful cases should be resolved in favor of upholding the warrant. More precedents. Albright v. State from 2022. Denied, whatever that. A defendant may invalidate a warrant by proving by a preponderance of the evidence that the affidavits used to obtain the warrant contain perjury by the affiant or a reckless disregard for the truth by him, and the rest of the affidavit does not contain material sufficient to constitute probable cause. Jones v. State Precedents, 2003, and Franks v. Delaware, 1978. My dad had a 1978 Dodge Diplomat. Loved that car. A 318 4-barrel. A defendant does not even receive a Franks hearing unless he first makes a substantial preliminary showing, both that the affiant knowingly or intentionally, or with reckless disregard for the truth, made false statements in the affidavit, and that those false statements were necessary to the finding of probable cause. Franks and Keelan v. State Precedents from 2014. More precedents, bunch of precedents, examples, cases. Basically, mistakes and inaccuracies of fact stated in a warrant affidavit will not vitiate. Oh my God, what is that? Will not vitiate? Is that vitiate? Oh my God. It's been a while since I've read stuff. The reliability of the affidavit, so long as such mistakes were innocently made. More precedents. Utley v. State, 1992, and the Franks again. Allegations of negligence or innocent mistakes are insufficient. Innocent mistakes. The burden to prove deliberate falsehoods or reckless disregards for the truth, as opposed to innocent or negligent mistakes, is a high bar. Wayne Scott v. State Precedents, 2023. The presence of intentional or reckless inaccuracies alone is insufficient to invalidate the warrant. Probable cause must no longer exist after those inaccuracies are excised from the affidavit. Keelan Precedents or something. Although it is not practical for police to include every piece of information relating to an investigation in a probable cause affidavit, an affidavit should include all material facts, which includes those that cast doubt on the existence of probable cause. Ware v. State Precedents in 2007. And more precedents, quoting Query v. State from 2001. Therefore, a defendant may also challenge a warrant by claiming the affidavit omitted material information, a reverse Franks claim. Oh my God. An example at 7, whatever, this Keelan thing again, precedents. To invalidate a warrant based on alleged omissions, the defendant must show that 1, the police omitted facts with the intent to make or in reckless disregard of whether they thereby made the affidavit misleading, and 2, inclusion of the omitted information renders the affidavit insufficient to establish probable cause. Or bunch of Keelan again. Franks protects only against omissions that are designed to mislead, or that are made in reckless disregard of whether they would mislead the magistrate. Keelan again, quoting United States v. Copley, 1990 precedents. 1. The affidavit did not contain false statements. Liggett's representation that Sarah Carbaugh reported seeing a muddy and bloody man. Yeah, she never said bloody. She said muddy in the first 2 times. Man who was wearing a blue-colored jacket and blue jeans was not a false statement. Well, no, but it should be considered because Judge Gall allowed it in. But if she didn't say it her first few times, you don't just get to start adding shit 3 years later. So technically it's not false, I guess. If you believe that she, much less one made knowingly, intentionally, or with reckless disregard for its truth. Allen's claim of falsity rests on the video of Carbaugh's June 7th, 2017 interview. Oh, would love to fucking see that. Oh, this video of that? I remember the quote, right? Oh my God. Where she is only heard describing the man as muddy, not bloody. Right. And she said he wore a tan or lighter colored coat with a dark hoodie or sweater underneath it. So he's even telling them, he said, she's to say it. She said a tan coat. He's fucking saying it. But Carbaugh was interviewed 3 times. Yeah, they keep browbeating people until they can say enough where they can spin it in their own narrative. All before the warrant affidavit was prepared. Yeah, because you had, I got to go on, sorry. And Allen ignores Carbaugh's description of the man in her second and third interviews, which showed that neither representation was false. In those interviews, Carbaugh described the man as bloody as well as muddy. No, but if the person gives the interview the first time, they don't just start remembering things afterwards. You guys are fucking amazing. So goddamn, 7, footnote 7. Carbaugh believed that she used the term bloody once in the first interview, but that it could not be heard on the video because she was mumbling. She also explained that at least 1 hour of her second interview with police was not recorded. This guy was given 130 years on this garbage. Listen to this. Carbaugh believes bloody was, I remember them saying this at trial. She believes she said it in her first interview, but the video didn't pick it up because she was mumbling. And then her second interview, like an hours were missed. An hour of her second interview with police was not recorded. These fucking people are amazing. You guys having a good time? Everyone okay? Just going to read on, okay, guys? I'm not ignoring you, okay? I think we'll get through this and then we'll have a little talk. Allen acknowledged at trial that she described the man as bloody 16 times in her third interview and said he looked like he had slaughtered a pig. She even marked where she saw the blood splatter on a picture of Bridge Guy during an interview. Liggett's representation that Carbaugh said the man was bloody was not false. Similarly, in Carbaugh's second interview, she corrected her previous inaccurate statement that the coat was tan. Oh, but I mean, if you say something in your first interview when it's fresh, you can't correct it. This is crazy, eh? They're fucking even admitting they did it. Yeah, this trustworthy Sarah Carbaugh, second interview, she corrected her previous inaccurate statement that the coat was tan. Inaccurate. It's not inaccurate. Well, it was inaccurate because she never said it. You can't just start adding shit. This is crazy. In that interview, she said that the man wore a blue coat. Yeah, because you guys browbeat her and showed her pictures. That one guy showed her pictures when she was drawing a sketch of Bridge Guy. He was going, look at this picture, look at this. And then they asked her, what color was his coat? They even admitted that in trial, too. This is fucking wild. Wore a blue coat with brown or tan sweater or hoodie underneath. Carbaugh also told police that the man in the Bridge Guy photo was the same man she saw on the road. And Bridge Guy was wearing a blue coat. Liggett's representation that Carbaugh said the man was wearing a blue coat was not false. Allen cannot prove falsity, but Allen cannot prove this. Like, his defense has to prove them. These people are amazing. This is exactly what they did. And they're saying, they're projecting here. Allen cannot prove falsity by cherry picking isolated statements and ignoring the totality of what Carbaugh said. Well, no, he can't, because Gull is patting him on the tushy, supporting all this bullshit. You guys can, because Gull allowed all this hogwash. Nor can Allen meet his high burden to show deliberate or reckless conduct merely by the fact that Leggett's affidavit related the information from Carbaugh's more recent statements to police, which she had never repudiated, rather than her first statement. That is particularly true in the context of an investigation this large and spanning so many years. Law enforcement interviewed huge numbers of witnesses, in many cases more than once. And many of those interviews, including specifically the interviews of Carbaugh, took place years before Liggett was preparing his affidavit. He may not even have remembered that 5 years earlier, Carbaugh had once described the coat as tan, or that she had not said bloody. In the first interview, given her overall certainty that she saw a bridge guy and he was bloody. See Utley precedents. Here's an example of that precedence, whatever this is. Finding Utley failed to demonstrate purposeful misrepresentation in the inclusion of several inaccurate or mistaken statements because the detective was in charge of an extensive investigation involving many officers and information coming from many sources. And as will be shown in subsection 2 below, Carbaugh's information is not necessary to the existence of probable cause. Therefore, even if the allegedly false statements were corrected, as Allen suggests, probable cause would still exist. Oh my God. 2. Material information defeating probable cause was not omitted from the affidavit. Allen also claims the affidavit omitted material information by failing to include details of Blair's description of the car she saw parked at the old CPS building that were inconsistent with Allen's Ford Focus and details of Blair's description of the man she saw on the bridge that were inconsistent with Allen's appearance. Footnote 8. Specifically, that the man appeared youthful in his 20s or 30s and had poofy hair, and that the car was shaped like a 1965 Comet and was a nondescript dark color, but was not black, white, or red. Allen did not show that these omissions were designed to mislead or made with reckless disregard about whether they would mislead, nor did he show that the inclusion of this information would have defeated probable cause. The requisite intent to mislead cannot be established merely by showing the fact of the omission itself. State v. Allen in 2022. But Allen points to nothing beyond the omissions themselves as proof that Liggett was being intentionally or recklessly misleading. Appellant's brief 64, 65. See the ID of some numbers, precedents or whatever that is. Failure to present evidence showing the omission of the defendant's exculpatory statement was a deliberate attempt to mislead, was fatal to his Reverse Frank's challenge, daring precedents, rejecting Reverse Frank's claim in part because, aside from noting these factual omissions, the defendant makes no attempt to establish that they were made deliberately to mislead or with reckless disregard, and other evidence refutes the suggestion that this was done to mislead. For example, Liggett included the information that a second witness, Terry Wilson, who saw a car parked there only minutes before Blair did, described the car as a purple PT Cruiser or a small SUV type vehicle. Appellate 3, 120. Purple is not black, and neither a PT Cruiser nor an SUV looks like a Ford Focus. Were Liggett attempting to create an impression that the witness had given descriptions consistent with Allen's Focus, then he would not have included those inconsistent details from the second witness. Indeed, had Liggett included Blair's description, it would only have emphasized that the probative value of the information was not that the witnesses had given a reliable description of the car's appearance. Their descriptions, after all, were not consistent with each other either. Rather, the information was probative because both witnesses had seen a single car parked in a suspicious manner at this location, at a time when other evidence established reason to believe it was Allen's car parked there. Similarly, Blair had told police that she recognized Bridge Guy as the man she saw primarily based on his clothing, which was a match. Bunch of numbers and precedents or something. Not on some characteristic of his physical appearance. It is therefore understandable, not suspiciously misleading, that Leggett's affidavit focused on that aspect of her description. More fundamentally, given the construction of the state's probable cause, neither challenged aspect of Blair's information was material to the existence of probable cause, which explains both why there was no intent to mislead or recklessly misleading effect in its omission, and why its inclusion does not defeat probable cause. The video from Libby's phone established probable cause to believe that Bridge Guy was the murderer. However, the probable cause to believe Allen was Bridge Guy did not depend on the accuracy of Blair's description of the man or the car or the extent to which those descriptions matched Allen. How convenient is all this stuff for them? It's like they can have it both ways with everything. The ambiguity is out of control. And the probable cause affidavit did not create any misleading impression that Blair had identified Allen as the man she saw or Allen's focus as the car she saw. Probable cause to believe Allen was Bridge Guy rested on the following facts. Bridge Guy encountered Abby and Libby on the High Bridge at 2:13 p.m. Appellant 3. Around or shortly after 1:30 p.m., a group of girls passed a single man on the trail walking toward High Bridge. Brianne Wilbur identified the picture of Bridge Guy as did I miss this? No, I read this. No, wait, did I miss number 9 precedence? Where is it? Oh, it's down here. Cool. Bridge Guy is the man they passed. So Brianne Wilbur identified the picture of Bridge Guy as the man they passed. Anna Spath similarly identified the man as wearing a blue coat. And the girls said that the man said nothing to them, although Riley Voorhees said hi to him. Footnote number 9. Because no Franks hearing was held, the state did not have an opportunity to present evidence in response to the motion. Where the state cites to the trial record in the discussion, it is consistent with the information contained in the probable cause affidavit, and thus is reasonably deemed to be evidence that was known by police at the time the affidavit was prepared. Although not mentioned in the probable cause affidavit, Voorhees testified at trial that she also immediately. Do I keep reading? Voorhees testified at trial that she also immediately. Something's not right there. Does it just end? Feels like. Can these go to the next page? Like, does it go down way to the bottom of the next page? This is it. I bet you're right. Yeah, sorry, I've never had that before. So like the footnote ended on this, so it goes way to the bottom of the next page. Number 9. So she also immediately recognized the picture of Bridge Guy as the man the girls encountered on the trail. And I gotta go way back up to this other page, 9. Blair was walking the trail to High Bridge and back between 1:46 and 2:15 p.m. When she reached High Bridge, she saw the man in the Bridge Guy photograph standing on the first platform of the bridge, and she passed Abby and Libby walking toward High Bridge as she was walking back to the trail entrance. Bunch of numbers. None of these witnesses saw any other male on the trail this time frame who could have been Bridge Guy. And none of these witnesses were represented in the affidavit as having identified Allen as the man they saw. It was Allen himself who provided the reasonable ground for believing he was the man these witnesses saw, and thus that he was Bridge Guy. Allen originally told police that he was on the trail between 1:30 and 3:30 p.m. Footnote 10. Oh my God, a mouthful. 10. The Freedom Bridge entrance where Allen entered and the group of girls exited is farther west, for example, farther away from High Bridge, than the Mears entrance where Blair entered. Thus, although Allen began walking the trail approximately 15 minutes before Blair did, he would have walked past the Mears entrance approximately 10 minutes before Blair entered, and thus would have been only a few minutes ahead of her on the trail. Abby and Libby were dropped off at the Mears entrance no more than 3 minutes after Blair entered, and thus were only minutes behind her on the trail. Therefore, Allen's contention that the evidence showed only that he was on the trail within the same 2 hours the girls were abducted is incorrect. Appellant's brief 65. The timeline is far more compressed than that. It leaves only a few minutes in which Allen theoretically could have left the platform and been replaced there by Bridge Guy in time for Bridge Guy to be seen by Blair, which is highly improbable given that Blair encountered no other man on the trail who could have been either Allen or Bridge Guy. Platform. Let me see if does 10 carry on again like that. No, so 10 just ends there. Could have been Allen. So that was the end of the. Oh, I should go back to where I started. See, I almost screwed up there. Where's 10? Because I went down to read 10 because I must have. There's 10 there. Oh, see, I'm getting good at this, guys, because I would have skipped this last bit. He said that he passed a group of girls without speaking to them as he walked toward High Bridge, that he went out onto the first platform. See, it makes much more sense when you read it properly, on the bridge, and that he did not see Bridge Guy while he was there. Bunch of numbers. Oh my. More, two lines of numbers. Thus, Allen had placed himself on the trail and on the High Bridge platform at the same time the witnesses saw Bridge Guy there. Moreover, although he could not recall with certainty by the time he was interviewed in 2022, Allen told police that he was probably wearing blue jeans and a blue or black Carhartt jacket that day. Oh my God, the guy had blue jeans on. Fuck. It's like 99% of men in that area probably stretchy, cheap Amazon blue jeans. Which was consistent with the clothing Blair saw and Bridge Guy was wearing. This created a reasonable probability that Allen was Bridge Guy, and therefore the murderer, regardless of any discrepancies between Blair's description of the man she saw and Allen. Blair's description of the man was not the foundation on which Allen's identification as Bridge Guy rested. I'd just like to comment, throughout this whole document, I'm reading so much doubt in his voice. And this idiot got a 130-year conviction on Richard Allen. And he's doubting himself. It's like they're having to prove themselves here. It's weird. Because I know it's like a response to the appellant brief. It's the appellee bullshit. But I just feel the doubt in his voice. Like, they nailed him 130 years on this. It just sounds so. He's not confident here at all. I feel it every paragraph. And the affidavit did not need to remove all doubt or definitely establish that Allen was the man the witnesses saw and recognized as Bridge Guy for probable cause to exist. Probable cause is not proof beyond a reasonable doubt. It is not even proof by a preponderance of the evidence. Putting my pop filter to precious, pertinent, precise pop use. Because I have this microphone with a pop filter. Probable cause requires only a reasonable probability, not a prima facie showing, now I'm going to think of every P. I've jinxed myself, I'm psyching myself out, of connection to the crime. Gates v. C. Maryland v. Pringle, 2003, describing probable cause as a reasonable ground for belief of guilt. Allen placed himself on the trail passing the girls and on the High Bridge platform at the time. Blair saw a man there, and those witnesses identified Bridge Guy as the man they encountered. That creates a reasonable basis to believe Allen was Bridge Guy. You feel the doubt in his own writings. He's just so doubtful. Like a 130-year conviction. In this context, it is not particularly significant that Blair thought Bridge Guy looked younger than Allen's age or had longer hair than Allen. Had Allen not placed himself on the bridge at the same approximate time that Blair saw Bridge Guy there, those discrepancies between Blair's description and Allen's appearance might be significant to the existence of probable cause. But, I mean, shouldn't it be because she's describing another person? Sounds like there's at least 4 or 5 guys running around there this day, plus McCain. Oh, my God. Then her description of the man would be the sole foundation on which Allen's identification as Bridge Guy rested. But Allen's statements place it, see, they only want the one guy. They don't want to think about her. All these other descriptions mean different guys. They're just like, oh, we don't need her description, even if it's not, because Allen said he was there. Yet it should be looked at as she's describing another person that's so far off. So, and then they can't bring in the third-party defense. And their main one, but 2 of their main witnesses, 3 or 4 of them are all describing different guys. They should. God, it's fucking amazing. But Allen's statement placing himself on the bridge at the right time to be the man Blair saw there by itself creates a solid foundation to reasonably believe he might be Bridge Guy. Oh my God. So they're saying, yeah, she's totally off of her description. Therefore, Allen said he was there, so forget this. Meanwhile, what if she's seen another guy? What if she's seen a 3rd guy or 4th guy? Like, come on. You can't just say, oh, she described someone different, therefore Allen said he was there, so forget what she said. No. You got to say what she said. And if she described a guy, then that means there's another guy. And, oh my God. So we can just disregard it. Fuck these guys. That man Blair saw by itself creates a solid foundation to reasonably believe he might be Bridge Guy regardless of any discrepancies in the description of his age or hair. Discrepancies mean when she says it's a 10 out of 10, that means she sees another person. Nick, you fucking even said this in here? Oh my God. It's like he's admitting there's a 3rd person there. And they can't have 3rd person. Oh my God. After all, Blair only saw the man briefly from 50 feet away. It stands to reason that her perception of his clothing might be more accurate than her perception of his age. A characteristic open subjective interpretation, or the length of his hair. And again, it was not necessary to eliminate all possible doubt that Allen was the man she saw for probable cause to exist, because he said it was him. So it doesn't matter if she's wrong. Yet, she might not be wrong. She might be right, and she saw somebody different. So it was immaterial if her description purportedly allowed for some doubt. Some doubt? Is that not the reasonable doubt? Like, he's admitting a lot of stuff in here. Wow. Oh my God. He's even admitting it. Oh, here. He's putting this in paper. So it was immaterial if her description purportedly allowed for some doubt. Whoop-de-doo. She saw someone different. C. Daring. Omissions of information that police smelled odor of marijuana throughout the neighborhood, and specifically along a neighbor's fence line, where they also found marijuana shake, was not material to probable cause, given fact that officers also smelled marijuana odor coming from inside the defendant's house. omission of information that eyewitnesses identified different person as the perpetrator with 100% confidence was not misleading or material to probable cause because police investigation had sufficiently cleared that person as a suspect. Stevens v. State precedents. A bunch of numbers and precedents, June 26, 2023. Omission of defendant's denial of alcohol consumption and asserted lack of sleep as alternative explanation for a crash were not material to evaluation of probable cause to believe he operated while intoxicated, operated a vehicle. Similarly, it was Allen himself who provided probable cause to believe it was his car parked at the old CPS building between 1:30 and 3:30 p.m. because he told police that was where he had parked and that no other car was parked there. A bunch of numbers, examples, pages. 11, a footnote. Although Allen called it the old Farm Bureau building, he said old Farm Bureau bureau, and they said, we think he meant CPS building. Then they say, could you have parked here? And he's like, yeah, I guess I could have. I parked there before. Boom, you parked there. These fucking guys were you there between 1:30 and 3:30? Yeah, I left. I was driving away by 1:31. Boom, he was there between 1:30 and 3:30. Fucking guys are amazing. There was no such building in the area, and he showed police on a photograph where the building was located, which allowed them to conclude he was referring to the CPS building. It allowed them to conclude it. Boy, these guys are wild. Wow. This was corroborated by the Hoosier Harvester video, which was off by 54-minute timestamps, but who cares, right? Which showed a car matching out. A car drove by, a black car, matching Allen's Ford Focus. Allen's Focus driving toward the CPS building at 1:27 p.m. after you changed the timestamp by 54 minutes. C8 channel 1 first filed a bunch of numbers and was consistent with his wife's information that they usually parked at the location when they walked the trail. A reasonable probability remains even if every witness who drove past gave an inconsistent description of the car they briefly saw, because the pertinent question is not whether the information excludes all doubt that oh my God, he says this. Like, they don't all have to match, right? Oh my God, it's wild. Excludes all doubt that the car was Allen's. The significance of the information from Blair and Wilson was not that they had identified the car as Allen's, nor did the affidavit misleadingly suggest that they had. Rather, the significance was twofold. One, between 2:10 and 2:15 p.m., the time when Bridge Guy was encountering Abby and Libby on High Bridge, and Allen said he was parked at this location. There was no other car parked there, thereby reducing the likelihood that someone other than Allen was also on the trail at that time. And two, the car was backed in right next to the building, suggesting an attempt to conceal the car's presence or identity in a state where we don't require a front license plate. How convenient for them. They don't. If it's so suspicious, why can't they just wave their pens, create a new law, making sure everyone has to have a front license plate? You see, because now 50% of the cars they got probable cause on if they're backed in. These motherfuckers are so, they don't care, because they could wave a pen and have one day they could change it so every car in Indiana has to have a front license plate, right? But they don't, because they love this. I wonder how many times, we should look up how many times they've used this to fucking nail someone's probable cause. The guy was backed in. He's so suspicious. Meanwhile, we don't care if people have a front plate. Fuck. Oh, God. The ambiguity is just off the charts of these people. The consideration of the omitted information does not remove probable cause. Footnote 12. To the extent Allen requests in the alternative remand to hold a Frank's hearing appellant's brief 67, 66 and 67, he does not cite to authority for the proposition that such a hearing can be held post-trial while an appeal pens. He also has not identified any evidence he could present at a hearing beyond the 133 exhibits he already submitted to the trial court in support of his motion. He had a full and fair opportunity to create an evidentiary record to support his claim, and this court has sufficient information to conclude that Allen cannot meet his burden of proof. Oh boy, where was I? 12, I'm looking for it. Where are you, little 12? There you are. The search warrant was valid and the evidence was properly admitted. 2. The court properly admitted Allen's confessions. Although Allen did not preserve this issue, the trial court properly admitted confessions Allen made to his family, F.G. Walla, and correctional staff. The confessions were voluntary, not the product of state coercion, and therefore did not violate his due process right against self-incrimination under either the 5th and 14th Amendments or Article 1, Section 14 of the Indiana Constitution. His other state constitutional claims are meritless, and the trial court properly excluded the IPAS settlement, which was not relevant to the voluntariness inquiry. This issue is unpreserved, although Allen renewed his pretrial objections to the confessions before the correctional officers and F.G. Walla testified. He did not request a continuing objection or contemporaneously object to testimony about the confessions. See Brown precedents. Absence of contemporaneous objection to admission waives issue. More importantly, he affirmatively stated he had no objection to the documents memorializing his confession to correctional staff and F.G. Walla. And he objected only on a different basis to recordings of his confessions to family. See Halliburton. Defendant may not affirmatively state at trial that he has no objection to the admission of evidence and then claim such admission to be erroneous on appeal. And he does not argue fundamental error, appellant's brief 6886, therefore thereby waiving that claim. Curtis precedents this court should find the issue waived. A. Allen's confessions were voluntary. Both the federal and the state constitutions prohibit the admission of involuntary confessions. Colorado v. Connolly precedents, 1986, and Pruitt v. State, 2005. A confession is involuntary when a person's free will has been overborne by violence, threats, promises, or other improper influences. Schneckloff v. Bustamante. Boy, that's quite a name. Schneckloff v. Bustamante. 1973, great year. Young Shibby was born. Wilkes v. State in 2009. Voluntariness is assessed under the totality of the circumstances. Under the federal constitution, the state must prove voluntariness by preponderance of the evidence, and the ultimate determination of voluntariness is reviewed de novo, though underlying factual determinations are reviewed only for clear error. United States v. D.F., 1997. Under the state constitution, voluntariness must be proven beyond a reasonable doubt, but the trial court's determination of voluntariness is reviewed as other sufficiency matters. Weisheit v. State, 2015. Pruitt, some other precedents examples. An appellate court will not reweigh. Oh my God, what is that word? Not reweigh? Not reweigh? The evidence of just, I've never seen that, I don't think. the evidence of voluntariness and views the evidence in the light most favorable to the trial court's rulings. Pruitt precedents. If there is substantial probative evidence supporting the court's conclusion that the statement was voluntary, that conclusion will not be set aside. 1. Coercive state action is a prerequisite to involuntariness under both constitutions. Coercive state action is a necessary predicate to a finding of involuntariness under the federal Constitution. Connolly precedents. The Constitution is not concerned with moral and psychological pressures to confess emanating from sources other than official coercion. ID at 170, quoting Oregon v. Elstad, 1985, and United States v. Guerrero, 1993, stating, this is the precedents, 2 examples, stating that due process does not protect the defendant from his own compulsions or internally applied pressure, which are not the product of police action. This remains true even when a defendant suffers from mental illness. A defendant's mental state is not enough to render a confession involuntary in the absence of coercive police activity. Smith v. State in Indiana, 1997, and United States v. Newman precedents, 1989. Precedence is evidence of a defendant's mental condition that impaired his cognitive or volitional capacity is never by itself sufficient to render a confession involuntary for purposes of due process. In Pruitt something, a bunch of numbers, stating the mere fact that the defendant is mentally ill does not render his statement inadmissible per se. Even an actively psychotic or delusional defendant can give a voluntary confession. Connolly and Pettiford v. State in 1983 precedents, People v. Rhodes in 1986 precedents, a defendant's mental condition is relevant to the voluntariness inquiry only insofar as it renders the defendant more susceptible to police coercion. Connolly, bunch of numbers. What's up, guys? Everyone okay? FBD, what are you doing, buddy? How you doing? I missed you. I haven't even looked at chat, guys. I'm so sorry. Hi to everyone. Don't think I'm ignoring you. Just trying to be serial, Shibby. FBD is in a pickle. Don't you start with me. Don't you dare, Dee. Leave his pickle alone. Don't you come in here waving your pickle, FBD, and distract me, young man. That handsome photo you. Look at you. Look at this guy. Oh my God. Did you guys know this pickle guy here? That's a fucking Doug Carter and Rosie O'Donnell love child right here. How you doing, buddy? Long time no see. Where the fuck was I? See, your damn pickle's all in my head now. Where the fuck? Alan, although Alan asserts coercive state action is not a prerequisite under the Indiana Constitution, he provides no analysis to support this assertion. Appellate's brief 8081. And the the Indiana Supreme Court has never held this. In Robbins v. State precedents of 1968, cited by Allen, contains only a generic reference to the state constitution, no separate constitutional analysis, and no suggestion that the definition of a voluntary statement under the state constitution differs from that under the federal constitution. Bunch of precedents, whatever. C.F. Schneekloth. Defining a voluntary statement in essentially the same terms as Robbins. No other justice has ever adopted Justice de Bruyler's conquering opinion in Lithium, v. State in 1987 precedents, suggesting that police coercion might not be required under the Indiana Constitution. Neither Robbins nor Justice de Bruyler identified the applicable constitutional provision, Section 14, or engaged in any analysis of it. and both cases involve statements made in response to police interrogation, not volunteered statements. Footnote lucky number 13. Let's go find it. It's the State v. Banks is a precedence in this footnote. Denied also contains no analysis of the text, history, or purpose of Section 14 to support its ambiguous holding that coercive police activity is not a prerequisite to involuntariness. Regardless, Banks also involved statements made in response to police interrogation of a severely mentally ill pickle suspect held in restraints and without proper Miranda warnings, which could be characterized as coercive state action. That was 13. Where were you? I gotta get myself. Oh, there you are. State constitutional questions are resolved by examining the language of the text, the first line of inquiry, the history of its drafting and ratification, case law, interpreting it, and the purpose and structure of our Constitution. Ajabu v. State, 1998. As explained in Section B below, under the Indiana Constitution, the prohibition on the use of involuntary statements in criminal cases rests solely on Article 1, Section 14's protection against self-incrimination. Section 14 protects only against compelled testimony. It is a right not to be forced to speak, and the compulsion it protects against is state compulsion. Aldridge v. State, precedents of 1959. Boy, oh boy. Section 14 protects against compulsion by legal process to give incriminating testimony. See generally Zoller v. Sweeney, precedents in 2014, explaining that Article 1's Bill of Rights protects Hoosiers' liberty from the reaches of their state government. Allen identifies nothing in history, text, or precedent that suggests Section 14 protects against a compulsion to confess that is independent of any state action, or that it applies to volunteered statements not made in response to police interrogation or state-compelled questioning. Without coercive state action, there can be no compelled testimony under Section 14. Look at that. Addendum 14 under Section 14. That's wild. Footnote. Sorry, I keep saying addendum. First month I was reading these, I kept saying addendum. It's a footnote. I feel like an idiot. If you listen to any old stuff, I said addendum for like a month or two. Right, Pegs? I forget who pointed that out to me. Somebody busted my chops about that. 14. Even if coercive state action is not a necessary prerequisite, it is indisputably an important factor under the Indiana Constitution. Wilkes, bunch of numbers. Based on the same facts discussed below, the totality of circumstances shows Allen's will was not overborne under Section 14. I don't even know what that meant, but I read it. I mean, I know exactly what it meant. I'll tell you guys later. 2. Coercive state action is absent in this case. None of the usual hallmarks of police coercion are present in this case. Allen's confession were entirely volunteered statements. They were not made in response to any law enforcement interrogation. Factors to consider in the voluntariness inquiry include the length, location, and continuity of the interrogation. Oh boy, Ashcraft v. Tennessee, 1944. Precedent since whatever. Confession made after continuous 36-hour interrogation with no sleep was involuntary. What? 36 hours, no sleep? God, if I miss 2 hours, I'm a baby. Allen, like right now, I should be sleeping the afternoon away like a grown man. Allen was not subjected to torture, beatings, or physical abuse by law enforcement. Brown v. Mississippi, 1936. Confessions made after repeated brutal beatings was involuntary. He has to reach back to 1936. Wow. He was not threatened with harm or offered any promises in exchange for his confessions. Lenham v. Illinois, 1963. Confessions made after defendant threatened with loss of her children unless she cooperated and promised leniency if she did was involuntary. And he was not held incommunicado and denied requested access to his family or legal counsel until he confessed. Haynes v. Washington, 1963. Well, he's really reaching here, eh? The alleged coercive state action in this case, like those examples, are the last time similarly this has happened. So they have to kind of look back that far to find similar actions to what happened to Richard Allen in 2023. 2023. Most of it happened. The end of 2023, beginning. They have to reach back that far to find examples where something similar happened. And all these are all about physical abuse. 1963. Oh my God. It basically hasn't happened in such a long time. He's reaching back. Shows you how wrong it was, obviously. The alleged coercive state action in this case rests solely on the conditions of Allen's confinement in the restricted housing unit. But the conditions of Allen's confinement did not rise to the level of coercive state action, rendering his confessions involuntary. While the condition of an individual's confinement prior to confession may bear on the question of whether government conduct was coercive, the mere fact that a defendant was held in disciplinary segregation or solitary confinement prior to making a statement is not sufficient to constitute the requisite coercion. The United States v. Geraldo Rivera, in 2015, rejecting claim of involuntary confession based on conditions of solitary confinement. See United States v. Giles, 7th Circuit in 2019. Confessions made after spending 2 years in solitary confinement was voluntary. What? So that's his example, saying, oh, look at, in this case, they accepted his confessions after he was locked up for 2 years. That's fucking, oh my God. So look at, if that's his precedent, it's like, hey, since it was here, you should accept it because this was only 1 year and 1 month. United States v. Kendra, circa 1981. Confessions made after 30 days in solitary confinement was voluntary. Conditions of confinement rise to the level of psychological coercion or compulsion, rendering statements voluntary only when they are so severe as to be intolerable circumstances that constitute outrageous conduct by the authorities. State v. McVeigh, 1980. It's not Timothy McVeigh, is it? Is that 1980? The bomb? No. Holding that the condition of state prison isolation cells were not so intolerable as to constitute coercion. See Miller v. Felton, 1985. Describing an involuntary confession as one procured by means revolting to the sense of justice, quoting Brown and Brooks v. Florida, 1967, per curiam, holding conditions of confinement rendered confessions involuntary when for 2 weeks the defendant had been held naked in a small cell with no window. What? No bed or other furnishings, and no facilities except a hole in the ground serving as a toilet, fed only 12 ounces of peas and carrot soup and 8 ounces of water per day, and denied all contact with the outside world. Conditions the court deemed a shocking display of barbarism. So that's Nick's example. Like, it wasn't this bad. Come on. This is what barbarism is. Barbarism, whatever. I forget. Like, we did nothing this bad. This, but I mean, fuck. Is that your standard? Like, if you didn't do this much, then it's okay? That's crazy. Donald V. Myers in 1966. Confession involuntary when defendant held incommunicado for 11 days in cold, unlighted, windowless cell where he was kept chained to a wall, fed bread and water, not allowed to bathe, and told he would remain there unless he confessed. So yours wasn't this bad, therefore it's okay? Oh my God. This fucking guy. Hey, Monday. Hey, guys. Sorry, I'm not ignoring you. I just should read this. So footnote 15 is right here. Allen's reliance on Littlefield versus Deland, 1981, is misplaced. Allen's brief 74. The mentally ill pretrial detainee in that case was held for 2 months in a strip cell with no windows, no interior lights, no bunk, no floor covering, and no toilet except for a hole in the concrete floor. Like, ours wasn't that bad. So was deprived of all clothes and given no bedding, was denied articles of personal hygiene, was given no opportunity for recreation outside his cell during the entire 2 months. And they're like, oh, ours was nowhere near this bad, so it's okay. This is wild. And was not permitted to have any reading materials in his cell. Wasn't it pitch black, he said? The fuck is he going to read? Braille? Although those conditions are several orders of magnitude worse than Allen's conditions. Yeah, he's going to read a book in pitch black while sitting on a hole in the ground, taking a dump. These fucking people are amazing. Yeah, ours wasn't that bad. Therefore, what we did is okay. This is amazing. The 10th Circuit did not hold that these conditions for a pre-trial detainee were per se unconstitutional. Rather, held only that they could not be imposed without procedural due process. So if they didn't find that treatment bad, then what we did, you cannot, it's impossible. Because ours was much less bad. It's like getting shot with 6 bullets is bad. Well, we only shot him with 2 bullets. Like, what the fuck? On appeal, Allen has not challenged the safekeeping order or the denials of his motion to vacate it or otherwise raised any claim of procedural due process denial with respect to his placement in the restricted housing unit. And I was on 15. Oh, it was right at the end there, so I can just carry on. Allen's, did that end? Yeah. Allen's confinement conditions were not outrageous or barbaric. Oh, well, compared to the examples you gave, no. You guys treated him like a king, yeah. He had an iPad, right? Fucking, what's her face? Susan Hendricks? You fucking garbage human, Susan Hendricks. Yeah. He had an iPad, therefore it wasn't solitary confinement. Everyone gets a good laugh on stage. Standing ovation at CrimeCon. Although small, his cell was the same size as the other restricted housing cells and was furnished with a mattress in a bed frame, a toilet, and a sink combo, all in one combo. It had a window to the outside. When Allen complained the window was scratched, the DLC replaced it. That's the second time they said that. Like, there's this tiny little window, and you couldn't see it because it was all fuzzy or scratched. Oh, they there. See? We treated him good. We replaced a tiny little window so he can look at a metal fence. He could dim the light in his cell, and he was never claimed that the temperature in his cell was oppressively hot or cold. It is undisputed that Allen was offered regular, nutritionally sufficient food. 16. Footnote 16. Although Allen sometimes refused meals, he never refused more than 4 in a row because he knew that would classify him as a hunger striker. He knew it. He was just doing enough to manipulate the situation. Sadistic people. And drink and was given all prescribed medications. He also had access to commissary. He was provided with laundry service and clean sets of clothes every week, even when on constant suicide watch. He was provided with a suicide smock. Ooh, that's what they called the Fred Flintstone thing, right? To wear. He would shower 3 times per week. Oh my God. You have to shower once a day. Easy. I got a quick shower in the morning, and if I could, a nice bath in nighttime to soak my nethers. Fresh Shibby helps you sleep too, except when precluded by suicide watch status. He received 1 hour of recreation time 5 days a week in indoor and outdoor exercise areas. He was allowed to have a Bible, other books, and reading material, and crossword puzzles in his cell. And he was offered a television for his cell, but declined the offer. They've said this twice. Why are they? Am I reading this twice or something? They've said this all twice. Allen was never held incommunicado. He was appointed legal counsel and received both in-person visits and private phone conversations with his attorneys. He received at least 2 in-person visits with his wife, a privilege afforded no other inmate in restricted housing. I really feel like I'm reading this twice. He could receive weekly visits from a chaplain upon request. Am I reading this twice? I'm going to keep going. This feels like I've read this. Allen had a tablet in his cell that he could use to make phone calls to family and others. Example, CC phone calls. When he broke his first tablet, he was given a second one free of charge, also a privilege afforded no other inmates. Allen could listen to music, watch movies, play games, and send written messages on the tablet. Actually, that's the first time I read that. So it is. Allen also received medical and mental health care. He was checked regularly by medical staff, including daily checks while on suicide watch. He also received daily checks by FG Walla or other mental health professionals while on constant suicide watch, and weekly checks otherwise. And he was offered at least 1 out-of-cell session with FG Walla every week. Footnote 17. Although Allen was shackled and handcuffed while taken to and from meetings with his attorneys, his wife, and FG Walla, Fangirl Walla, those restraints were removed during the meetings. Thus, all of Allen's basic needs were met. He was given food, clothing, shelter from the elements, access to sunlight, basic hygiene, medical care, mental health care, opportunity for exercise, opportunity for intellectual stimulation, opportunity for spiritual care, contact with loved ones, and contact with his attorneys. Yeah, he had it all. You guys are so nice. These conditions were not so barbaric as to overcome a person's will. That's why he stated all that other precedence. So when they wanted to show you how bad things were for people, and then when they read theirs, it's like it lessens it. And I guess it's less. It was not really, really horrible. It was only really horrible. Like they're thinking, we'll show you really, really, really horrible stuff that people had done to them. And ours was only really horrible. Therefore, it's okay. Conditions of confinement, not so harsh as to be coercive. When defendant was fed, permitted to shower, and exercise regularly, could make phone calls, and could receive visits. McVeigh. Conditions of confinement, not coercive, when defendant could shower and exercise 3 times per week and was fed. Moreover, except for the several ways in which he received more favorable treatment and the video-only camera in a cell, Allen's confinement conditions were identical to any inmate in restricted housing. Under the logic of Allen's argument, then no statements made by inmates in restricted housing, such as their jail phone calls or Mirandized interviews, could ever be admissible. But he cites to no authority, and the state is aware of none, that supports such a novel proposition. That is because the conditions of restricted housing, while undesirable, are a far cry from what is necessary to create an involuntary confession, except he's a pretrial detainee, innocent until proven guilty at this time. He wasn't convicted at this time. Jesus Christ. 3. Alan's confessions were not caused by the alleged coercive conduct. Like, all of this is what happened to him a year before he went to trial. As an innocent until proven detainee who was supposed to be in a jail, was sent to a maximum security prison because they said he was suicidal. And I'm going to get into it. 3. Alan's confessions were not caused by the allegedly coercive conduct. For a confession to be involuntary, the coercive state action must be causally related to the confession. Connolly 165, emphasizing the essential link between the coercive state action and the resulting confession. Alan's argument assumes that the conditions of his confinement caused his brief period of psychosis, and that his psychosis caused his confessions. But both premises are belied by the record. Moreover, the state did not attempt to deliberately exploit Alan's confinement or mental illness to procure a confession, explaining that a defendant's mental condition is relevant to involuntariness only when the police seek to exploit this weakness through coercive tactics. The confinement conditions did not cause Alan's confessions. The conditions did not become more oppressive before the confessions began, nor did they become more benign before Alan stopped confessing. And the state never made any threats or promises regarding those conditions predicated on his cooperation or willingness to confess. Moreover, the confessions were not coextensive with Alan's period of psychosis. He began confessing before he was psychotic, and he continued confessing after he was no longer psychotic. Alan was already confessing in early April 2023. Suicide companion logs, but it was not until April 13th that Alan became gravely disabled, and April 14th, basically it's 10 days after you put him in like under suicide watch, and he had no contact with anybody. It took you 10 days to break him. Right here, because it was on the 4th. He was admitted April 4th, 2023. He was put on suicide watch, and by the 14th, 10 days later, they had him broken. Couldn't contact anybody. They treated him differently when he was on real suicide watch, even though he's there on safekeeping as suicide watch. So crazy that his psychosis and manic behavior became significant, and he was involuntarily started on an antipsychotic medications. By May 2nd and 3rd, 2023, Alan no longer exhibited significant symptoms of psychosis, manic behavior, or lack of impulse control. Footnote 18. On May 3rd, F.G. Walla added a diagnosis of brief psychotic disorder with marked stressors to his record for his presentation. How convenient. Brief psychotic disorder. Within the last month, this diagnosis applies when a person exhibited one or more symptoms of psychosis, not better explained by another diagnosis that lasted more than 1 day but less than 1 month in reaction to an event that would be markedly stressful to anyone in the circumstances. Wow, this is amazing. United States of America. This is an innocent until proven guilty citizen on pre-trial detainment, not convicted of any crime ever. Clean record this guy had. Oh my God, where was that little addendum thingy? Where the fuck is it? Where are you? What number was it? It was like 18. Here it is right here. Right. And he never thereafter presented any significant symptoms of psychosis or mania. Yeah, you guys fixed him. You broke him, and then you fixed him. And then you stopped breaking him, and you got better. That's what it is. They fucking force-fed him Haldol, broke him, tortured him, And then when they stopped, he started getting better. Therefore, they're like, oh, no problem. That's good. But he continued confessing. And February 4th, 24, Suicide Companion logs, Allen's most detailed confessions to F.G. Walla occurred on April 5th and May 3rd. Wasn't that 2023? No, it was 2023. What are they saying? 2024? Yeah, it was 2023. And all the way to then, January, February, March, April. Yeah, he went in on April. He went into the suicide watch on April 4th, 2023. Allen's most detailed confessions to F.G. Walla occurred on April the 5th and May the 3rd. Before and after his psychosis, 19. Even if this court finds the confessions made during the period of psychosis between April 13th and May the 1st to be involuntary, they were merely cumulative of the numerous admitted confessions made outside that period, and the erroneous admissions of cumulative evidence is harmless, and Boner v. State precedents. Now, half of these confessions were inmates were yelling at him, Richard Allen, why did you kill Abby and Libby? And when he replied, I killed Abby and Libby, like in a question form, the guards wrote verbatim down what he said. Therefore, he literally said it. Like, if you write it down, clip it out of context, I killed Abby and Libby. That's what he said. But half of them, the guards even admitted, he was responding to other inmates yelling at him. They were like, Richard Allen, why you killed Abby and Libby? And he's like, I killed Abby and Libby, like in a question form. But if you don't add that, connotation, that inflection of the words, the pronunciation, I forget the name of it, but so if you clip it out of context, yeah, he said, I killed Abby and Libby. And he's like, I killed Abby and Libby? That was half of them. The guards even admitted to that in their testimony. So where the fuck was it? 19. His desire to confess was not correlated to either a change in his confinement conditions or the onset of psychosis. Moreover, the record provides a reason why Allen began confessing in early April 2023. April, what a nice name. That has nothing to do with the conditions of confinement or their impact on his mental health. First, Allen experienced a markedly stressful event around the beginning of April. He received his legal discovery at the end of March, beginning of when? April. And he had a meeting with his attorneys on April the 3rd, 2023. His behavior began to change and worsen immediately after these two events. The discovery materials forced Allen to face the horrifying evidence of what he did to Abby and Libby. Images and events he had been able to ignore and repress over the 5 years in which his guilt had gone undiscovered. He was also confronted by the realization that the state had sufficient evidence for a jury to convict him and that he was likely going to spend the rest of his life in prison. And he had to confront the realization that his family would be seeing these graphic images of what he had done. These realizations would be stressful regardless of whether one was already in pretrial detention, the conditions of that detention, or one's mental health. Second, after spending time in Bible study, Allen said he found Jesus and accepted God into his heart on March the 21st, 2023. He became preoccupied with religious matters and increasingly concerned about whether he would be reunited with his family in heaven and whether they would still love him if he had committed these crimes. Acknowledgement and repentance of sin is an important teaching in the Christian faith. A new convert's fresh concern with the status of his soul and the will of his God would lead to a desire to confess his sins, particularly when he The conversion happened in close proximity to the inescapable confrontation with the sin through the legal discovery. It is at least as plausible, if not more so, that the combined effect of his religious conversion and his receipt of discovery with its concomitant, is that a word? Concomitant realities to be faced is what caused his confessions, not the conditions of his confinement or his mental health. In addition to undermining any causal connection between the conditions of confinement and the confessions, the record also shows the state did not seek to exploit Allen's mental status to induce a confession. The purpose of his placement was not exploitive. Allen was validly transferred to the DOC as a safekeeper, see these numbers, and placed in a restricted housing cell out of concern for his own safety, both from other inmates and from himself. Number 20. Because he was a safekeeper, he was not subject to the DOC's policy regarding placement length in restricted housing, and had he remained in the county jail, he still would have lived in a similar cell with constant video surveillance and minimal interaction with other inmates during comparable recreation time, but with no in-person visits with family or legal counsel. This placement gave him significantly greater access to mental health professionals to help his pre-existing depression and anxiety problems than he would have had in the county jail. The state sought to offset the problems of social isolation by providing Allen with access to mental health professionals and a chaplain, regular exercise, 5 hours a week, regular exercise. Oh my God. People are amazing. Regular contact with his family, reading material, movies, music, and an offered television that he refused. What man was going to turn down a television? Get lost. In addition to Allen's access to legal counsel, F.G. Walla, I almost said it, advised him that he should not talk about his case with anyone other than his attorneys and assured him that he did not have to talk about the case to receive mental health help from her. The state made no attempt to interrogate Allen after his mental health began declining. When he became psychotic, the state did not ignore that condition while he continued to confess, but instead promptly initiated antipsychotic medication to restore Allen to his baseline mental health. Viewed as a sufficiency matter, the evidence supporting the trial court's ruling proves voluntariness beyond a reasonable doubt under the Indiana Constitution. Even reviewed de novo, the preponderance of the evidence proves voluntariness under the federal Constitution. B. Allen's other state constitutional challenges are meritless. The admission of Allen's confessions did not violate the due course of law provision in Article 1, Section 12, the Appellate's Brief 81-82. Criminal defendants do not have any general due process rights under Section 12. See, criminal defendants, but he was innocent until proven guilty, pretrial detainee. The due course of law provision of Section 12 applies only to civil cases. Church v. State. Harris v. State precedents. Due process in criminal cases is protected only through the specific rights guaranteed by other provisions of Article 1. Thus, under the status constitution, the use of involuntary confessions is prohibited only through the Section 14 privilege against self-incrimination. Allen has waived his claim under Article 1, Section 15, because he raises it for the first time on appeal. Appellant's Brief 82 and 83. In his motion to suppress, and at the pretrial hearing, Allen alleged violations only under Sections 12, 13, and 14 of the Indiana Constitution. He did not allege a violation under sections 15, a bunch of numbers. At trial, he merely incorporated his arguments from the pretrial hearing. Constitutional claims raised for the first time on appeal are waived. In precedence, Indiana 2016. And appellate consideration in the first instance is particularly inappropriate when the constitutional claim is dependent on potentially disputed facts. Layman v. State, precedence 2015. See Ajabu, something more precedence declining to address section 15 claim raised for first time on appeal. Regardless, our Supreme Court has specifically declined to interpret Article 1, Section 15 as prohibiting anything more than physical abuse. 21. Footnote 21. Holy shit. 21. Allen erroneously cites Helton v. Miller, precedence 1860, for the proposition that the Indiana Supreme Court has held that Section 15 applies to solitary confinement. Appellant's brief 82. First, the language Allen quotes on page 585 is not part of the opinion of the court. See ID at 582, pronouncing the judgment of the court, ending the opinion. The quoted language is from the brief of Mr. Crawford, the attorney for the appellants, which follows the opinion in the reporter. See ID. Mr. Crawford submitted the following argument. See also the ID 589. The brief for the appellee is lost. At that time, the court sometimes appended verbatim recitations of the parties' arguments to the end of its opinions. Bunch of McQuigg v. McQuigg. A McQuigg v. McQuigg. Two McQuiggs fighting. That's their last name, McQuigg. Somebody from 1859 precedents. Second, the court's opinion does not address or even mention Article 1, Section 15, nor does the issue decided in this case have anything to do with the constitutionality of solitary confinement. Helton, 14, Indiana. Some numbers deciding whether the statutory law of this state allowed convicts in the state penitentiary to be sent outside the prison walls to work. So where was I again? 21, right? Oh, look at that. I did the blue thing. Kelly v. State, precedence, Indiana 2025, declining to reconsider this interpretation. See Ratliff v. Cohn, 1998, precedence. Recognizing that Section 15 violations are limited to torture and beating of prisoners, Section 15 is not a catch-all provision applicable to every adverse condition accompanying confinement. Kelly, quoting McQueen v. State, Indiana, 1999. Allen has not contended either in the trial court or on appeal that he was subjected to physical torture or beatings by correctional staff. See, we didn't beat him, so therefore it was okay. His complaints about the conditions of his confinement do not present a viable Section 15 claim. See Moore v. State, 2002. Refusing to extend Section 15 to claims of emotional abuse inflicted by incarceration. McQueen extended pretrial incarceration does not implicate Section 15. Ratliff, incarcerating 14-year-old juvenile in adult woman's prison, did not violate Section 15. C. Harmless error. Even if all the confessions were involuntary, their admission into evidence is harmless. The erroneous admission of an involuntary confession is subject to harmless error review. Arizona v. Beaumonte, 1991 precedents. Constitutional errors must be harmless beyond a reasonable doubt. meaning that they did not contribute to the verdict. Hall v. State, Precedents 2015. The timeline, eyewitness evidence, including Allen's initial statements to police, alone creates an overwhelming certainty that Allen was Bridge Guy, and thus the murderer. Allen admitted he parked near the Freedom Bridge entrance and began walking the trail about 1:30 p.m., which was corroborated by the surveillance video capturing a car matching the appearance of his focused driving toward the Freedom Bridge entrance at 1:27 p.m. Bunch of numbers and timestamps. He admitted he was likely wearing a dark Carhartt jacket with a hood, blue jeans, either tennis shoes or work boots, and had a hat with a bunch of precedents and timestamps, which matched the clothing worn by Bridge Guy. Allen identified himself as the man who walked past the Wilbur Voorhees group on the trail around 1:30 p.m. Wilbur and Voorhees both admittedly recognized the picture of Bridge Guy as the man who had walked past them. They both described two different people. Riley Voorhees, go read their descriptions. Fucking Riley Voorhees, this guy's wearing all black. Black boots, black jeans, black jacket, had a mask on his face, a square jaw, hair coming out of his thing. Such bullshit. Allen also admitted that when he reached Highbridge, he walked out to the first platform and stayed there for a few minutes. Blair entered the trail at the Mears entrance at or just after 1:46 p.m. And when she reached Highbridge, she saw a man on the platform, whom she immediately recognized as Bridge Guy. Neither Blair, Wilbur, nor Voorhees saw anyone else on the trail who could have been Bridge Guy. They all saw three different people, though. Idiot. Go read their descriptions. Betsy Blair's description, Bree Wilbur's, and Riley Voorhees. Go. I dare you. And Allen acknowledged seeing no one else who could have been Bridge Guy. As she walked back towards the entrance, Blair passed Abby and Libby on their way to Highbridge, and by 2:13 p.m., the man Blair, Wilbur, and Voorhees saw. Which one? Which one of those three? The man Allen had effectively identified himself as being, because nobody else said they were there, or therefore it's him by default, right? Was following Abby and Libby across Highbridge and ordering them down the hill, while armed with a gun. By 2:32 p.m., Libby's phone had stopped moving, and by 3:11 p.m., Libby was not answering the phone when her father called, and she and Abby had failed to meet him when he arrived to pick them up. Now, Derek, he called at 3:11. He was by 3:11. Libby was not answering the phone when her father called. Yeah, because they said 3:11. He was crossing Wilson's Bridge, heading to get there. Shortly before 4 p.m., Carbaugh saw a man she recognized as Bridge Guy walking westbound on 300 North. My example is toward where Allen admitted he had parked his car. Yeah, so McCain admitted he parked his car there too. His clothes were covered in mud and fresh blood splatter. So Carbaugh, when she drives by the Mears entrance, she says she sees a bunch of people freaking out, looking for people. They looked worried. There was a bunch of people. Then Carbaugh drives by Bridge Guy, right, covered in blood and that, and therefore Bridge Guy walks past a bunch of people, and they're looking for girls, and the guy walks by, and not one person sees him, nor is he picked up on the Harvester camera walking by. Such hogwash. Just didn't happen. Because Carbaugh in her testimony says when she drove by the camera at Hoosier Hardware Store, 356, she drives by Mears entrance and sees a bunch of people out there looking worried. And then right before the cemetery, 357 or whatever, she says she sees Bridge Guy covered in blood. Therefore, he's walking towards the Hardware Store. He has to walk right past that Mears entrance. And there's all these people there looking for girls, and a guy walks by covered in blood. And nobody sees him. was I? But Wilbur and Voorhees, a certain. Well, I'll start here. Given Allen's admissions placing him on the trail and on the High Bridge platform at the right times to be the man seen by Blair, Wilbur, and Voorhees, there is certainty that the man they saw was Bridge Guy. The absence of anyone else on the trail who could have been Allen or Bridge Guy, and the tight timeline this combined evidence created in connection to the abduction and murders. The only reasonable conclusion to be drawn was that Allen was Bridge Guy, the person who murdered Abby and Libby. Like, the only reason he's concluding it's just by default. Like, who else could it be, right? Meanwhile, they're saying they've got evidence and all this proof. Other evidence corroborated this conclusion. Right. Most significantly, the unfired Winchester .40 caliber cartridge found by the girls' bodies was forensically matched as having been cycled through Allen's .40 caliber handgun. Yeah, it was Oberg's subjective opinion. She believed. She looked at it with her eyeballs. A hamster ran around in a wheel on her head, in her brain, and she spit out some words that said, I believe. It's my subjective opinion. I believe that this bullet matches this bullet that came from this gun because of the tool marks, unfired bullet. Just the tool mark extractions of when you rack a gun and a bullet flies out, not even shooting one. And she fired a bullet to match. It's so ridiculous. Allen and all the jurors said they didn't believe it. The ballistics, they just kind of overlooked it. Therefore, Allen had an identical unfired cartridge, the only piece of Winchester ammunition found in his house, in a keepsake box. Allen had no possible innocent explanation for how a cartridge that had been in his gun could have ended up at the murder scene. Well, it's because your Ober said it was his gun bullet. It was her opinion. You don't have proof other than some person's opinion that works for you. Bridge Guy had a gun and used it to compel Abby and Libby to go down the hill. An ISP trooper who had listened to over 700 of Allen's phone calls opined that it was Allen's voice heard on the video saying, down the hill. Although Allen had 12 old cell phones in his bedroom closet, he did not have the cell phone he had told police he had with him on the trail in 2017, creating a reasonable inference that he destroyed the phone because he knew it contained evidence of his guilt. Oh, well, you idiot. He fucking came to you. Dan, this guy is using this as proof that Richard Allen did it, right? He doesn't have his phone 5 years later when we talked to him. Well, Nick, Richard Allen handed his phone 3 days after the bodies were found to Dan Doolin, sitting in front of the Save-A-Lot, sitting at a picnic table wherever they sat. Dan Doolin held this phone in his hand, and he says it. I took the battery off, and he was writing the IMEI and all those numbers down. Dan Doolin held this fucking phone 3 or 4 days afterwards, and they're giving Richard Allen shit for not owning it 5 or 6 years later. The gall, the nerve of these people. Dan Doolin held this phone 3 or 4 days after when Richard Allen came to them in his hand and took the battery off. And now he's thrown it in his face that you don't have this phone, therefore this obvious that you're guilty. Well, we find that phone. It's going to have Doolin's fucking fingerprints all over it. Idiots. And now Doolin's the captain of the Department of Natural Resources after the most epic screw up in all the history of the Department of Natural Resources. He didn't screw up. He got a promotion. Allen also displayed consciousness of guilt by lying to police. Although he originally, you wait 5 years, somebody's going to get something wrong. You can't imply he's lying. Dan Doolin also lost his original statement. He recorded it. Dan Doolin lost the recording. And then if Richard Allen doesn't match what they said he said back then, 5 years later, then he's lying. But then Doolin had a recording of it. Where's that recording, Doolin? Play it. You won't need to ask him again. You'll have his recording. But Doolin, they lost it. Oops, I can't find it. He recorded that meeting in front of the Save-A-Lot. The nerve of these people. He told police he was at the trail from 1:30 to 3:30 p.m. And the testimony of Wilbur and Voorhees proves that he was arriving at the trail, not leaving it at 1:30 p.m. When the police re-interviewed him in October of 2022, a mere 5 years later, Allen claimed he was at the trail much earlier, from 12 p.m. to 1:30 p.m. Well, you lost his interview. You lost the recording of it. So you can't say he's lying when you can't prove to match it to anything different other than what your people say, your narrative of what was said. When you lost the recording of the initial meeting, he voluntarily came to them. And Allen claimed he was at the trail much earlier. So, showing he understood the damning implication of the initial timeline, he admitted. While police executed the search warrant at his house, Allen said multiple times, "It's over." I really feel like they're repeating a lot of this, but I'm going to go on. In the face of this powerful evidence of guilt, the jury did not need to rely on the confessions at all to return its verdicts. D. We have a quick drink, guys. What's up? Hey, see-through. Sorry, guys. I'm totally ignoring chat. Are you guys okay? I should just get through this, right? Not get through it. I'm enjoying reading it. And we'll have time for shenanigans. Tons of shenanigans going over this. Let's do this. Serial Shibby is here. D. The order ends. So hello to everybody if I missed you. I'm not ignoring you. I'm trying to not see you because I might get distracted. Hello. The order and settlement agreement from an unrelated lawsuit against the DOC was properly excluded. I got to remember, I'm Nick McClelland here, right? So, just as the ultimate ruling at a pretrial suppression hearing is no longer at issue following a completed trial, slowing some numbers, so also are subsidiary evidentiary rulings made during the course of a pretrial suppression hearing. The available issue now is the evidentiary rulings made during the trial, but Allen challenges only the exclusion of the IPAS order settlement agreement at the suppression hearing, Appellant's Brief 71. He cites no authority to support the contention that this is a live issue for appellate review, and he makes no cogent argument addressed to the IPAS ruling at the trial, the Appellant's Brief 71-72. This court should find the issue moot or waived. Regardless, at both the suppression hearing and at the trial, Allen was allowed to elicit evidence regarding DOC's policy limiting offenders with SMI to 30 days in restricted housing. The reason for that policy, the detrimental effect to mental health caused by social isolation, the undisputed facts that Allen had diagnosed mental health conditions upon entry to the DOC and met the definition of SMI in April of 2023, and that he remained in restricted housing for approximately 13 months. Oh my goodness, bunch of numbers. He was also permitted to present expert evidence regarding his mental health and the impact of social isolation on mental health. The only thing excluded was a court order and settlement agreement from an unrelated civil lawsuit that was the original genesis of the DOC policy. Thus, Allen was able to introduce the evidence relevant to his voluntariness challenge. Current DOC policy in effect during Allen's pretrial incarceration was relevant and was not excluded. A settlement agreement from an earlier unrelated civil lawsuit, which appeared to have expired before Allen's arrest, was not relevant, and any minimal probative value it might have possessed was outweighed by the dangers of unfair prejudice and confusion of the issue. See Indiana Evidence Rules 401 and 403. Allen acknowledged there was a lot of things in the IPAS settlement that don't have anything to do with this particular case, and that he wanted to use the IPAS documents to attack the DOC's history of treating mentally ill offenders. This criminal trial was not the proper forum to litigate a civil rights challenge to the way mentally ill individuals are treated in the DOC. The DOC was not on trial here, and the court properly refused to allow Allen to attempt to confuse the issue that the jury was to decide. Finally, an error was harmless. Indiana Appellate Rule 66A. Given the nature of the evidence, Allen was allowed to present and the lack of any coercive state action. The court can be confident that the IPAS lawsuit documents would have made no difference to either the trial's court ruling that the confessions were voluntary or to the jury's evaluation of the weight to give those confessions. 3. The trial court made proper evidentiary rulings. The trial court's evidentiary rulings were correct and did not deprive Allen of his right to present a defense. Trial judges are better at making evidentiary calls than appellate judges. Therefore, trial courts are given wide deference. In this area, Snow v. State Precedents 2017. In many cases, a court could admit or exclude evidence, and an appellate court won't meddle with that decision on appeal. Evidentiary rulings are reviewed only for a manifest abuse of discretion. Forget v. State Precedents 2004. An erroneous evidentiary ruling is harmless if, given all the evidence in the case, the error's probable impact does not undermine confidence in the outcome. Ico v. State 2023. Federal Constitution errors must be harmless beyond a reasonable doubt, meaning that they did not contribute to the verdict. Whole bunch of numbers. The constitutional right to present a defense is not absolute. Crossland v. State 2025. Defendants must comply with well-established rules of evidence to assure both fairness and reliability in the ascertainment of guilt and innocence. Quoted Chambers v. Mississippi, 1973. What a great year. Oh my God, 1973. Love it. The right to present a defense trumps an evidentiary rule only when the rule is arbitrary or disproportionate to the purposes it is designed to serve. Holmes v. South Carolina, 2006. Evidence Rule 403 and hearsay rules do not unconstitutionally limit the right to present a defense. Bunch of numbers. A. The trial court properly excluded inadmissible evidence. 1. The investigatory sketch of Bridge Guy. Allen has waived this issue. The trial court granted the state's motion in limine to exclude the police sketch drawn from Blair's description of the man she saw on the bridge. Rulings on motions in limine do not preserve errors for appeal. Swaney v. State, 2002. Allen did not attempt to introduce Blair's sketch at trial, so he was waived this issue. Waiver notwithstanding, Blair's police sketch was inadmissible. Allen sought to admit Blair's sketch as substantive. I added an extratative, so it's substantive evidence that Blair did not see Allen on the bridge. 22. Footnote. Or this. Sorry, let me get that. There we go. 22. Allen's additional arguments that Blair's sketch would impeach Carbaugh's identification or show bias in the investigation, Appellant's Brief 89, are waived because he did not make those arguments below. See Washington and number of precedents. But the sketch was not relevant for this purpose because, as the trial court noted on, and Allen concedes, Blair did not make an eyewitness identification. of Allen as the man on the bridge. So that's why they didn't say it in court, right? They never had her say that's him. So then they didn't have to bring her sketch in because they would show the jury it was fucking completely totally different person. Blair identified Bridge Guy as the man she saw on the platform of the bridge. She did not identify Allen as Bridge Guy. Don't you love that? Or even writing it. She identified Bridge Guy, but she did not identify Allen as Bridge Guy. But we say he's Bridge Guy, therefore her identification. See Evid R401. Allen's identification as Bridge Guy came from Allen. Oh, because he said he was on the. From Allen identifying himself as the man Wilbur and Voorhees saw, and identified as Bridge Guy, and placing himself on the platform at the right time to be the man Blair saw there. So he's saying, forget Wilbur and Voorhees, who they say they saw. They say they saw a guy. He says he was there, therefore they saw him. And they all three describe a completely different person. Further, any slight probative value was substantially outweighed by the danger of unfair prejudice and confusion. See Evid R403. It was undisputed that composite sketches are used as an investigatory tool to generate leads and are not used to identify or exclude a suspect. A sketch is not a whatever. Just join two of them together. Cross your eyes and stare at two photos. You'll see one guy. Blair's sketch was an artist's interpretation of her description of Bridge Guy, that she said it was a 10 out of 10 match. Yeah, that's what they do. They show eyes. They have those little books, and they flip it over. Eyes, nose, mouth, And when he did that with her descriptions and drew a photo for her while her sitting there saying, yeah, she almost pooped her pants when she saw it, how good it was, right? But Blair's sketch was just an artist's interpretation, meaning he got it wrong. Like he could have got it wrong, yet she's sitting there saying, no, it's perfect. It's perfect. A Bridge Guy. And it was impossible to remove artist bias. Oh, artist bias. What does it matter if it's bias when she says it's a perfect description? You fucking God, how can I have this both ways? It's just so goddamn ridiculous. We're doomed. We're doomed as people. If the ambiguity here, like they can just have it both ways. Look at what he's saying here. Her description of Bridge Guy, and it was impossible to remove the artist's bias. But who cares about his bias? Because she says he nailed it. That's 22. Footnote 22. Allen did not offer any foundation from Blair's sketch artist for admission of this sketch. Oh my God. The danger of unfair prejudice was twofold. One, the jury could misuse the unreliable. Your witness said it was perfect. You asshole. Sketch is substantive evidence. And two, the jury could misuse the sketch to exclude Allen when Blair had not purported to identify Allen. Yeah. It's exculpatory, Nick. That's Allen's use of the sketch would have misled and confused the jury. What? Yeah, because it would go to that third party defense that they weren't allowed to use, right? It's fucking people. The sketch was also inadmissible hearsay. 24. Sketch is inadmissible hearsay. You know how many times they've fucking locked people up because of these sketches? Now all of a sudden when it's inadmissible hearsay? Fucking let's go back in history. See how many times people were locked just to sketches. Now that it's exculpatory, it's inadmissible hearsay. Fucking amazing. Amazing. Allen's arguments on was it 24? 24, yeah. Allen's arguments on appeal that the sketch was admissible because it was not a statement under the hearsay rule and that it was an adoptive admission by the ISP are waived because he did not raise these arguments for admission below. Bunch. See Washington, whatever. Evidence Rule 801 all allows a prior statement of identification because these statements are believed to be reliable. 25, footnote 25. Allen's reliance on Roe v. State, 1974, is misplaced. There, the sketch was admitted to impeach the identifying witness's identification of the defendant. Here, Blair did not identify Allen. Yeah, so there was no identification of the defendant to impeach. Yeah, because you told her not to identify him in court, right? Why did this is weird, like, because if she's like, why, when did the defense ask her, and she say, I don't know if it's him or not? It's fucking well. She's in court on stand. He's sitting right there at the table. Three of them got up, and not one of them pointed to the guy sitting right there. Robinson v. State in 1997. Blair's sketch was not a prior identification of Allen, so he could not use it as substantive evidence that she did not identify him. See Blount v. State, 2014. The rule is a means of positive identification shortly after perceiving the person. It would not apply to prior identification of a different person. Allen's new claim that the sketch was impeachment evidence is waived. The appellant's brief 89. Excuse me. Ooh, just a little burp. It looked like I'm laying down almost in my recliner. He did not offer it for that reason or attempts to impeach Blair with it. Moreover, it would have been cumulative. On cross-examination, Blair testified that she had described the man she saw as a young, boyish man in his 20s or 30s, of average height with brown, poofy hair, and no visible facial hair or hat. The jury could compare this description with Bridge Guy and with Allen. Allen makes no persuasive argument that the sketch would have been any more impeaching than Blair's description of the person. See Weed Man v. State. Great name, Weed Man. Indiana, 2014. Exclusion of cumulative evidence is harmless error. And as argued in section B below, any error was harmless due to the overwhelming evidence of guilt. 2. Tobin's testimony. Tobin's testimony was inadmissible because it was not relevant to an issue before the jury. Tool mark identification has at least two sub-disciplines, metallurgy and firearms identification. ISP forensic firearms examiner Melissa Obert testified that she used the association of firearm and tool mark examiners AFTE tool mark identification methodology, and opined that there were 3 different tool mark areas of significant agreement. See, they did use the 3. He says it right here, because they only had the 1. But the reason they got the 3 is because she fired the bullet. Therefore, in the beginning, they only had 1. And I said it in my thing, that's the extractor arm. But after she fired it, she then gained 2 more. Therefore, she has 3, because it would then be the rifling, the striations of the projectile passing through the bullet, the barrel of Richard Allen's gun, and the pin hitting the hammer hitting the end of it. So there's all 3. And the reason she gets away with it is because she fired 1. Therefore, she says the fired round, the empty casing matches the gun. Therefore, it matches the same as the other bullet. Therefore, she can conclude that she has all 3 of these markings now, because she even says it in her testimony that it would be wrong for her if she only had the 1 discipline, which was the extractor arm. It's not enough for them. It would be wrong. She even says it in her. It would be wrong for us to make a conclusion on just 1 discipline. That's why she fired it, not because she wasn't strong enough to recreate the marks, because they could have just got an ape like Jerry Holman or any gigantic man to rack that gun hard enough to recreate Richard Allen's pressures, right? But that's bullshit. They did it. They said that so they could fire a round, therefore saying that this empty cartridge, she looks at it and says, it matches the unspent round that was found beside Libby's foot. Therefore, she fired this one. She says those two shells match, the unspent and the spent one she fired. And then she knows that the projectile came out of this bullet and the hammer hit this unspent one. Therefore, she has all three. She created this evidence. That's why she fired it, to create. There were three. Tool mark identification methodology, and opined that there were three different tool mark areas of significant. Yeah, she created them. And the only reason she has three is because she says that the spent round that she shot, the marks on that cartridge, the spent one, matched the unspent one. Therefore, she's got Richard Allen on three things, not just one. So fucking gobbledygook right here in front of y'all. Different tool mark areas. So I'm going to read that again. Tool mark identification methodology, and opined that there were three different tool mark areas of significant agreement to show that the cartridge at the scene had been cycled through Allen's Sig Sauer model P226 caliber handgun. She had all three, guys. She had all three. I fucking told you when I read that. They had the tool mark from when it shoots out of the gun. They bullshit and said that she couldn't rack it hard enough to recreate them, so she had to fire a gun. But they could have easily got a gigantic guy to recreate it even harder than Allen would have. But that was their bullshit excuse, so she could fire a round, therefore saying the unspent round 16 by Libby's foot matches the spent one she just fired, and now she knows those two matches. She can then say that the projectile passing through the barrel has striations on the lead, and the hammer from the pin hitting that. Now she has all three to say that, because she says, yeah, the bullet I just fired matches Richard Allen's gun, because she says that, and then she links. She just says that the spent round matches the unspent one that they found at the scene. Just her opinion. Therefore, she has all three of these. It's fucking amazing. Different tool mark areas of significant agreement to show that the cartridge at the scene had been cycled through Allen's Sig Sauer model P226 40 caliber handgun. Defense expert Eric Warren, also a forensic firearms examiner who uses AFTE methodology, testified that he reviewed Oberg's report and did not agree with. Yeah, so when your partner disagrees with you, he did not. So then they take it to the boss, and he gets to choose if Oberg was right or he is right to disagree with her. And he's the third vote. It's crazy, eh? So Oberg's report, she had another officer compare it. They had a name for it, a dumb name like a checker. And he didn't agree with her. So Oberg had to take it to her boss, and he overruled him and went with her. So it was 2-1 vote. Fucking such a gobbledygook. Did not agree with her process of comparing a cycled cartridge with a fire cartridge. Yeah. The other guy said no. So, let's go ask my boss. And he says it's okay. And found insufficient documentation to support her opinion. Right. The guy, her coworker, disagreed with her. And she just went to her boss, and her boss said, I agree with her. That's it. That's it. No wonder she's never wrong. She literally says it. I'm never, ever wrong. It's because it's your goddamn opinion. It's just a subjective opinion. No shit. How can you be wrong? It's your fucking opinion. It's like, I believe I can fly. You know, this was the battle of the experts. He's playing it off like so dismissive of the defense, bringing that up, like as if they're jerks. For like, this was the battle of the experts. Allen also proffered William Tobin, an expert in metallurgy. Tobin is an open critic of the AFTE and all firearms identification methodology. He believes that discipline is unreliable and should not be admitted in court. The trial court properly excluded this testimony because it was not relevant to an issue before the jury. Tobin's proffered testimony went to the reliability and admissibility of firearms identification evidence. The Abigail v. State, 2023, noting Tobin's testimony discrediting the reliability of firearms identification generally and the AFTE theory specifically in a Fry hearing. The trial court, not the jury. See, you know why they did that? Because they had a black box test and they tested a bunch of them. But what they didn't tell you is they threw out 20% of them inconclusive, right? So they acted like out of 100, they only got 3 wrong and 3 wrong in the affirmative and 2 right in the net. Like they were wrong about 2 and they missed 3. So out of 100, they say they were 95% right. But they didn't tell you that there was 20 or 30% were inconclusive, meaning they're getting about 70% right, 60% out of 100. They didn't tell you about that part. So, because the black box ones, it's such bullshit. But when she does it over, she's not allowed to go inconclusive. She has to come to a decision. She can't say it's inconclusive. And she says it would be wrong if she had to pick. But then they get over it by saying, we have a coworker look at it. And if they disagree, then our boss votes in favor of one of us. It's such bullshit. The trial court, not the jury, determines whether expert scientific testimony is admissible under evidence rule 702B because the scientific principles upon which it rests are reliable. See Turner v. State, Indiana, 2011. Allen never offered Tobin's testimony to exclude the firearms evidence as based on unreliable scientific principles under Rule 702B. Because the trial court found the firearms identification evidence admissible, it was for the jury to determine the credibility of Oberg and Warren and assign weight to the evidence. And none of them, they threw it out. They don't care. None of these jurors thought it was good. But that right there should be, reasonable doubt. Those jurors thought if 1 or 2 pieces were unreasonable, then they just throw it out or something, right? Or reasonable. The jurors were misled to believe that all the evidence, all of it had to be unreasonable. Because even one juror mistakenly said unreasonable. When it's just, there has to be a couple pieces that create reasonable doubt. They thought they could throw this, and that. And then if all the rest of it wasn't unreasonable, then he's guilty. They fucking tricked these, or they're just dummies. The credibility of Oberg and Warren and assign weight to the evidence. Tobin's proffered testimony was not relevant to credibility. Tobin is not trained in forensic firearms identification, does not do firearms examinations, and did not examine the evidence. The Pruitt v. State in 2004. Stating that an expert in one field of expertise cannot offer opinions in other fields absent of showing of competency in the other area. Tobin was not qualified to offer testimony against the weight or credibility of the forensic identification evidence. See in Turner. Allen's claim that Tobin's testimony was offered to impeach Oberg's credibility is incorrect. Hey, Skinny Monday. If I missed anybody, where the fuck was I? Let's go from here. Sorry, guys, I'm kind of ignoring you. It's by intention because I would enjoy you guys so much. I'm going to get distracted. Dewey, Dee Monday. KB. Ja Rule is in the house. Hi, guys. I see you. You matter. Just know I'm not ignoring you. Allen offered Tobin's criticism to discredit the accepted established methodology under the AFTE. This criticism had nothing to do with Oberg's work specifically and her credibility was as an expert. Moreover, Allen extensively cross-examined Oberg, and he offered Warren's expert testimony to counter Oberg's opinion. Both Oberg and Warren acknowledged the criticism and ongoing debate in the firearms identification field by the President's Council on the Advancement of Science and Technology and the National Academy of Sciences. Thus, much of Tobin's proffered testimony criticizing firearms identification evidence was presented to the jury. So I'm reading it as Nick, okay, guys? I'm not making fun of this. This is Nick McClelland's voice. I perfectly matched it with I'm using one of those voice boxes to talk through. So like when kidnappers call, this is called the Nick McClelland Truck Nuts Boss Recorder voice changer. For this reason, and due to the overwhelming evidence of guilt discussed in Section B below, any error in the exclusion of Tobin's testimony was harmless. 3. Audio of Allen's movement videos in DLC. Allen presented 15 videos of his movement within the DLC during April through June 2023 to show how the environmental conditions affected his mental health, which impacted the credibility of his confessions. The trial court sustained the state's hearsay objection to the audio of Allen's statements, so the jury saw Allen but did not hear what he said during those movement periods outside his cell. Oh, I almost missed it. Look at that little number there. Trying to trick me. 26. Let's go get it. 26. The exhibit itself has audio, but Allen muted the sound when it was published. Oh boy. Thank you. Only the video, not the audio, was relevant to present his environmental conditions. Allen's sole argument on appeal is that his statements were not hearsay under Evidence Rule 801C, because the statements showed his state of mind. Appellant's brief 98. But Allen's statements do not facially pertain to his state of mind. Exhibit D, a triple D. Better than my double D in chat. Triple D. She's better. She's one D better than your DD. Just kidding. I'll take a double DD over this triple DD any day. My double DD has, substance. She's amazing. Right, DD? Right. And Allen's attempt to use them for that purpose shows that he was offering them for their truth. He wanted the jury to accept the substance of his statements as true reflections of the contents of his mind. A defendant who does not testify during trial cannot introduce exculpatory statements made outside of court in order to enhance his credibility. Because the statements are self-serving, generally untrustworthy, and not subject to cross-examination, Sweeney v. State, 1998, Allen also makes no argument to show the admissibility of others'. Why is they putting this always after an S? Like, can you pluralize that? Others'? Is it just me? Like he's always putting girls' others' admissibility of others' statements in the videos, although he clearly relies on those statements for the truth as well in the appellant's brief 98, 99. Further, Allen had adequate other means to impeach a fangirl Wallace testimony, including cross-examination and his own expert witnesses, appellant's brief 98, but it would not impeach F.G. Wallace's testimony about Allen's, no, he did it right. Well, there's not an S on the end, so what am I even saying? Presentation on a particular day with videos of him on different days, even if audio was presented to the jury. because, psychosis is fluid. This evidence was thus unlikely to have an impeaching. Oh, did I miss? No, I read that one because that was at the very beginning. I just forgot. It was published. Wait, what was the last? So this evidence was thus unlikely to have an impeaching effect. The jury was able to view Allen's environmental conditions and his behavior in the movement videos from April 5th to June 20th, 2023, in light of his expert witnesses' testimony of his psychosis and delirium, like Shibby's getting. What time is it? I'm supposed to be sleeping. Oh my God, it's 4 p.m. I usually go to sleep by like 12 or 2. Like a normal man. Any error in the exclusion of the audio was harmless as explained in section B below. For Allen's other 2 phone calls on April 3rd, 2023. The state presented 1 jail call by Allen on April 3rd, 2023 at 5:14 a.m. over Allen's objection that 2 other phone calls that day at 3:12 a.m. and 8:45 a.m. also had to be admitted under Evidence Rule 106, the doctrine of completeness. That'd be a great movie, The Doctrine of Completeness. The Swamp Thing, I feel like that's a creature. The Doctrine of Completeness. That's a great name. Holy fuck. The Doctrine of Completeness. Imagine that, like you're a boxer and you get like a nickname. And this the Doctrine of Completeness. Fucking love that. The trial court's ruling that each call in full met the Doctrine of Completeness, coming in at 313 pounds. The Doctrine of Completeness in this corner was correct. Allen cites to no authority showing otherwise. Appellant's brief 99-100. Blah, blah, blah. A bunch of numbers. Miller something. Failure to make cogent argument supported by citation to authority waives issue. To authority waives issue. You should have a little comma there or something. The Doctrine of Completeness does not mean that once the state presents one full statement by a defendant, the defendant is entitled to put in any other statements he made at different times. See Hawkins v. State, 2008. Rejecting defendant's Rule 106 argument that because the state had presented some entire jail phone calls made by the defendant, she was entitled to present other jail phone calls she had made. Blah, blah, blah. Liberians v. State in 1999. Holding state's presentation of one police interview did not entitle the defendant to present another statement he made to police. Evidence Rule 106 is limited by fairness, and where distinct conversations are involved, fairness does not require that the trial court allow admission of otherwise inadmissible hearsay. Hawkins, some numbers. Regardless, any error was harmless as explained in section B below. 5. Dr. Grazian's testimony that Allen's confessions were false. Dr. Grazian testified to the effect of solitary confinement, the symptoms of delirium, and that he saw Allen exhibit symptoms consistent with delirium and false memories. Now, this is one of the guys, I think, where he describes, he said Allen was presented, like, when they ask him time, place, and day, like what year is it, who's the president, and all that. This, I think, this is the guy. One of them said, "Oh, at this time when he made this, he was perfectly, lucid and talking sense." But then they showed a video of that exact same time, and he was out of his mind. Then he had to change his. I'm not sure if it was this doctor exactly. One of them did. It's like, oh, okay. Now that I look at this video, he could have been, in a good state of mind. So they busted him, the defense, and nothing happens. They just move on. Because he's on the stand. One of them was on the stand saying, At the time of this confession, he's perfectly lucid and acting normal. We asked him date, time, and the president, and he knew everything. And then he's like, oh, you sure? Let's look at this video of an hour before he talked to you. And he's fucking putting shit in his mouth and dancing naked. Oh, my God. He was out of his mind. They broke him. And this guy's like, oh, maybe I made the wrong choice. I'm not sure if exactly this guy, but it was one of those older guys. So anyways, state doctors. The trial court sustained the state's objection to Dr. Grazian's testimony that Allen's confessions were false. 27. Little footnote 27. 27. If Allen wished to elicit anything more from Dr. Grazian than his opinion that Allen made false confessions, he failed to make an offer of proof regarding any such additional testimony and has waived the claim. Dilac v. State, 2006. Failure to make offer of proof regarding excluded expert testimony waived issues. The trial court ruled, 1, the witness could not testify to whether Allen's statements were consistent with the facts of the case because the witness did not know the facts. And 2, it was one thing I do miss with Nick is he hasn't said the word judge. He's go, judge. I hope I get to say that. I don't think I will. Because he's not talking. He's not in the court talking to Judge Gall. Damn it. It was for the jury to decide if Allen's confessions were false. None of the 3 bases Allen argues for admission were offered below, so he has waived these arguments. Appellant's brief, bunch of numbers and letters. See, Washington. The only basis offered below was that Dr. Grazian knew the facts because he had reviewed all kinds of stuff. It might not be that guy, might be thinking of somebody else. But this would be an insufficient foundation for an opinion. Further, Evidence Rule 704B provides that witnesses may not testify to opinion concerning intent, guilt, or innocence in a criminal case. The truth or falsity of allegations, whether witnesses testified truthfully or legal conclusions, Allen sought to present testimony from Dr. Grazian that Allen's statements in his confession were false, which was impermissible under the rule. See Kincaid v. State, 2021. Expert may testify generally about false confessions, but may not testify as to the truth or falsity of the defendant's confession. Shelby v. State, 2013. Dr. Grazian testified that Allen's behavior and statements were consistent with delirium, so he was not denied an opportunity to present this evidence. Allen's combination of the 3 alleged errors, all of which centered on the admission of his own statements, to claim a systemic violation of due process is unpersuasive. Appellant's 101. Appellant's brief 101. I had a brain fart there. I was like, what? Allen fully, completely described the environmental, physical, and mental health conditions leading up to his confessions, as well as expert testimony on both the effects of Allen's confinement and his mental health. But neither Allen nor the state could present opinion evidence that Allen's confessions were true or false. That is not an unconstitutional infringement on the right to present a defense. As discussed in Section B below, any error was also harmless. 6. Perlmutter's testimony that the murders were ritualistic. The trial court properly excluded Perlmutter's testimony, opining this was a ritual killing, proffered in support of Allen's theory that this was a ritual killing committed by Odinus. 28. Well, why do you think anyone would say that? Would it be that 60% of your evidence included this type of person, and then you fucking Judge Gall disallowed it all? You guys are amazing. 28. Perlmutter is not an expert on Odinism. And also that fucking guy's not an audio expert, but he was allowed to listen to Richard Allen's phone calls and say it was him. See, these people Their people can all be experts without anything. Just because that one guy, I forget his name, he listened to a bunch of phone calls, therefore he can match Richard Allen's voice to the bridge guy voice. And he's an audio guy, but the guy who sits there and listens to the phone calls, not somebody who, but they accepted that. These people are wild. Expert opinion testimony is admissible only when it will help the trier of fact. Rule 702 is restricted by evidence Rule 403, which permits the exclusion of evidence that will confuse the issues or mislead the jury. Buzzard v. State. 1996. Third-party motive evidence must establish more than a speculative connection to the crime to be admissible. APPELLEE v. State, 2009. McIntyre v. State, 1999. And Ruiz v. State, 2010. Exclusion of expert at bench trial was harmless because his proffered testimony was speculative. Perlmutter's opinion that this was a ritual killing, an opinion she reached before seeing any evidence in the case, was too speculative to be admissible as third-party motive evidence. It was in motive in search of a suspect. As discussed, subsection 7 below, no evidence connected any oddness to the murders or placed them at the crime scene. No. I'm not even going. I got to go past. Evidence theorizing alternative motives for crimes that was unmoored from any identified third-party suspect connected to the crimes was properly excluded. It was a speculative motive. There is no history of ritual human sacrifices in Odinism. Yeah, but these guys were meth-induced psychosis, cherry-picking, wannabe fanboys LARPing in the wood Odinists, like Brad Holder, who admitted to walking through the woods to listen to the branches. Brad Holder said he walked through the woods and listened for Odin to speak to him through the tree branches. Fucking said it to Purdy and Lemler. Lori Lemler, the female cop. And according to an Odinist, the sacrifice of children would be contrary to the principles of the religion. Yeah, to the religion, but not a fucking guy who's meth-induced psychosis idiots drinking from horns. Fucking. Even Perlmutter acknowledged that, apart from this case, she had knowledge of only one other Odinist ritual killing, and that case remained an open investigation with no confirmation of a perpetrator or a motive. Even at the very least, if it's, somebody trying to stage the scene, right? What's his face? Purdue Turco said it was there, whether it was like a fanboy or whatever. It was the exact type of guy. He described Holder as the exact type of guy, but since Holman lied in his sworn affidavit about what Turco even said, he went and cleared Holder. But if Holman didn't lie about what Turco said to him and add things or omit things, then clearing Holder, he would look like a fool, because Holder is the exact type of guy he described as a fanboy LARPing in the woods. Fucking Holder makes ceremonial knives. He has fucking tattoos on his hand that look like Abby's stick configuration. He said to the Lemler and Purdy that he walks through the bushes, the forest, listen to the tree branches for Odin to speak to him through the branches. And he's taking photos of all that fucking shit on the ground with branches that just look like runes. And he literally he's a blacksmith who makes ceremonial knives. Which means she actually could not identify any other example of an Odinist ritual killing. Perlmutter also acknowledged that outdoor killings committed with a knife are not necessarily ritual killings. Excluding alternate motive evidence that was speculative. Yeah, speculative, because all this 80% of the shit in your discovery was not allowed in trial. So yeah, you could say that now, because you guys all knew in the beginning Gull was going to refuse all the shit. So you gave it to the defense, and they took it because who wouldn't? You handed them all this evidence, and it turns out you knew Gull was going to not allow it, in my opinion. Yeah. Now it looks stupid when you look back at it, but at that time when the defense dropped that fucking Frank's motion, and everyone's started having a conniption fit. The fucking not one of the people on the guilters or prosecution side thought that shit was not going to be allowed at trial. Not one of those people. Now they're all saying, oh, the defense was stupid for going with it. Who was saying it back then? Not one of them. Afterwards, they're able to armchair quarterback. But at the time in October of 2023, when that fucking photo leak was going on and that Franks was dropping, people were losing their shit. Nobody thought on any side that all that Odin shit was not going to be allowed at trial or third-party defense. Nobody. And all those guys knew it. Like Nick and all the Mullins and Holman, they knew Gull was going to disallow it all. That's why they fed it to them. Like, haha, take the bait. And it was a motive based on inaccuracies with respect to the alleged symbolism of the crime scene. There was no F in blood on the tree. That was a misapprehension caused by the reddish tints in the tree bark. Well, you dipshit, fucking 10 different cops in their testimony referred to it as the F tree. Fuck you. When a chemical was applied that turned the blood white, it was apparent there was no second horizontal line necessary to form an F. The blood formed only an upside down L. It wasn't an S, it was an L. Neither Perlmutter nor Allen have ever contended that an upside down L is a rune or an Odinist symbol depicting runic alphabets. The blood patterns on the bodies and on the ground were inconsistent with the bodies having been hung upside down. Oh my God, he's actually saying this? Did he say that at a trial? Or because they're responding to the appellate stuff, right? As Odin is typically depicted, the sticks on the bodies were fundamentally ambiguous. Professor Turkle found it equally plausible they were not attempted ruins at all. No. He didn't. You guys badgered him in the second time, but the first time, Turkle said, either way, it was present. He couldn't tell if it was like what was that again? Posing as in fantasy, like really believed, like a mixture of fanboys cherry picking, or just like somebody staging it to misdirect and kind of like set these guys up. But he said it was present. He didn't fucking say that, asshole. Fuck these guys. Professor Turkle found it equally plausible. Yeah, after that second time, you went badgered him in his second one, or third time, whatever it was, that later one where Jerry went back to talk to him after lying about knowing who he or she even was. Yeah, you fucking badgered him. The guy probably thought he's got tenure as a state Purdue, they probably whispered to somebody and went and talked to the governor. He went and talked to probably the dean of the whatever university, whatever they are. And they whispered to Turkle, hey, maybe you should be a little more agreeable with Holman when he shows up this time, And because they fucking badgered him. I know it. Yeah, he definitely sounded different the second time. And could offer only conjecture. Oh, right. And Turkle said that the FBI misled him by putting all this extra stuff in their email. So he kind of just thought that's what the FBI wanted to hear or something bullshit like that. The first time. Now, the second time, he was like, yeah, now if the FBI didn't kind of lead me into it, I wouldn't have said all that or whatever. Such bullshit, eh? And could offer only conjecture as to their meaning, if it was assumed arguendo that they were intended to be ruins, as the arrangement of the sticks did not in any obvious way spell a word. As seen in the crime scene photographs, the sticks were much less suggestive of ruins than in police sketches he was initially shown. Well, hey, asshole, go and tell, what's his face? Not Boucher, who was the other cop? Ryan Winters, after Leggett told Ryan, Boucher, the guy from Georgia, to get lost with all his screenshots of Brad, the citizen. Boucher took his shit to the Indiana State Police, and Ryan Winters, when he saw that picture of Brad Holder's ruined hand tattoo, he jumped out of his chair because he seen the original crime scene photos of Abby and Libby, and he thought that Brad Holder, Logan's dad, his son's girlfriend's dead body, had a stick configuration exactly like the tattoo on his hand that he saw in the photo. And he wasn't basing it on that shitty purple dress fake photo of the girls laying on the trees. This cop, Winters, saw the original real crime scene photos. And when he saw Brad Holder, he went straight to Holman and then. So you go tell a cop that, because fucking Ryan Winters testified about it. He freaked out. Almost jumped out. He almost bumped his head on the roof, this Ryan Winters. And it was after Liggett or somebody from Unified Command told Boucher to get lost. That guy who took all the screenshots from Georgia, the citizen. Luckily, that guy went to the state police to push it further because most people would have just given up. Anyway, with respect to the sticks on Libby, even Perlmutter could say only that she believed they had specific meaning to the offender. She could not identify any rune or symbol they purportedly formed. 29. Ooh. 29. Contrary to Allen's representation, Appellant's Brief 104, Perlmutter testified that the sticks on Abby, not the sticks on Libby, were the bind rune, which she theorized combined a Gibo rune and as an Isa rune based on a Facebook posting and picture by Brad Holder. Perlmutter's ritual killing opinion was inextricably intertwined with her assessment of things depicted on Holder's social media. Yeah, but as shown below, Holder was definitively cleared as a suspect. Yeah. You cleared Holder after fucking Turco described a guy exactly like Holder. Yet the only reason you cleared him is because Holman, in his sworn affidavit, lied about what Turco said, added things Turco didn't say, and omitted, and then obfuscated the whole fucking existence of Turco. He didn't know who he or she even was. Yeah, then you cleared Holder. And then after Purdy and Lemler went back to talk to Holder, after Boucher Winters made Holman go check Holder, they go out to talk to Holder, and Holder says to them too, that he knows they're cops. Holder says to them, yeah, I listened. I walked through the forest, I walked through the woods, and I listened for the branches. I listened for Odin to speak to me through the tree branches. And then they take it back to them, Holman and them, and they clear him again. They clear Holder again. A guy who makes ceremonial knives. They clear him again. Yep. Perfect. So 29. Where the fuck was I? Am I going to mark these better? Where are you? There you are. The FBI's Behavioral Analysis Unit was unable to verify or find support for the theory this was an Odinist killing, determining that neither the blood on the tree nor the sticks on the bodies clearly depict, capture, or present known aspects of Odin's or its symbology. Yeah. They were there to hide the girls, right? And Holman even said at 2025 CrimeCon on stage that not only were the sticks on Libby to hide her from being seen, the angle of Libby's sticks were to prevent her from being seen from Weber's private drive. Therefore, if you looked over from Weber's private drive, you would see Libby because she wasn't being blocked by that stick. So it's ridiculous. Anyway, particularly in the absence of any evidence placing any Odinist at the crime scene or directly connecting one to the crime, or like Robert Ives saying non-secular stuff at the crime scene, right? The trial court acted well within its discretion in declining to admit evidence of speculative alternative motive that would have confused the issues, turning the trial into a debate over disputed claims of Odinic. Never ever seen that. That's the first time I've seen anyone say it like that. Odinic. Symbology. Is that even a fucking word? I would rather see them say Odinite, which I believe Baldwin trolled them with Odinite because they knew it was a rock. But I just love watching any of those prosecutor-friendly people read Odinite. They would get stuck on it and go, oh my God, Odinite's a rock, man. Odinite's not, oh my God. I think Baldwin and Hennessy were trolling them when they did that, in my opinion. Symbology. But an Odinic. Boy. And distracted the jury from the issues before it, namely whether the evidence proved Allen committed these murders. That is especially true because motive was not basis through which the state purported to identify Allen as the perpetrator. Because motive was not a significant factor in the proof of guilt, the probative value of evidence of an alternative motive was correspondingly low and easily outweighed by the dangers of confusing the issues and misleading the jury. See Holmes and Numbers. Requiring proffered third-party evidence to survive evidence rule 403's balancing analysis does not violate the constitutional right to present a defense, as discussion in section B below. Any error was harmless. Oopsie. Yeah, oops, we lost 70 hours of evidence. Video, oops. And then 5 weeks, we lost a video. The first 5 weeks of evidence, we lost everybody. Witnesses, statements, people that came in, the family, and fucking all the suspects. We lost it all. Oops. Then 5 weeks goes by, and Mullins says he did it again. Lost 5 more weeks or whatever. And then on trial, he's like, all the lists I wrote up for it, to note all the stuff I lost, I didn't put dates on it. Oops. And he just kind of laughed it off on the stand. Baldwin's like, don't you think you should have put dates on it? He's like, oops. Whatever, man. I didn't put the dates on the lists of all the shit I lost. And even when you're in grade 3, you guys all know, you took your paper back to the teacher and it didn't have a date on it, he'd make an ass of you in front of the class. Oh, put your date on it. Go back to your desk. Put your fucking date on it. And you'd be like, oh, I'm an idiot. I'm 8 years old. I know better. And this fucking Holman was on the stand mocking these people. 7. Evidence of 2 third-party suspects. The trial court properly excluded Allen's proffered alternate suspect evidence pertaining to Brad Holder and Patrick Westfall. Footnote 30. Below, Allen asserted that several other individuals acted in concert with Holder and Westfall to commit a ritual killing. He never claimed below that Holder and Westfall had acted alone. On appeal, he has abandoned any claim that the evidence pertaining to those other individuals should have been admitted. Well, yeah, because Gull didn't allow it all. So they had, you fucking asshole. This Nick would have, without Judge Gull, Nick would have fucked this up such a long time ago. She babied him all the way through this. I usually say patted his tushy. He would have fell flat on his face without Judge Gull. Allen, all those idiots, Mullins especially, Doolin, fucking Holman, bunch of dumbest guys we've ever seen. Perfect yes men, and they all get fucking promoted afterwards because they did good. They fucked up really good, and they all got rewarded, promoted. Doolin's the fucking captain of the DNR. Mullins back to being the chief of police. Holman's fucking going to be running Doug Carter's job soon, probably, or something. Anyways, Allen was permitted to present evidence challenging the quality of the police investigation and their long-term suspicion that more than one individual had been involved in the crime. Yeah. It wasn't just the Saudi defense that some other dude did it. It was the Mahdi defense that many other dudes did it. My opinion. Fucking wild. It all came from their discovery. But the court excluded his specific third-party suspect evidence. Right? Like Elvis Fields. 8 cops got in a van and went down and investigated Elvis Fields. They broke off in pairs of 2s in a house and talked to Mary Jacobs and her husband and a kid. And they were investigating. They talked to Elvis. they thought enough to take Mary Jacobs for a lie detector test because Elvis said all that shit to fucking Murphy, who was a cop in an investigation directly. It wasn't hearsay. He said it right to his face. And then they can't have a third-party defense of Elvis Fields? Fuck them. That's so wild. But the court excluded specific third-party suspect evidence because Allen failed to, because you guys didn't, I can't even start. Any nexus between those individuals and the crimes. Right. Yeah, there's no nexus to Elvis Fields. So you guys wasted months and drove in a fucking van. 8 cops drove to Elvis's family to investigate. And when you send Mary for a lie detector test, that's not the first thing you do. You do that when you're sure somebody's a suspect, right? So Elvis Fields, for him not to be at trial, to be admissible, evidence must be relevant. It must tend to make a fact of consequence more or less probable than it would otherwise be. Plus, Elvis Fields looked exactly like Teresa Liebert's mailbox sketch from 8 o'clock on the 13th in the morning. He looked exactly like the baggy-eyed Lord of the Rings Gollum sketch from Teresa Liebert. Or it could have been Logan Holder, but I think I saw Elvis's baggy eyes. Even Dave McCain had those baggy eyes. But Elvis Fields and Dave McCain's baggy eyes, evidence which tends to show that someone else committed the crime logically makes it less probable that the defendant committed the crime and thus meets the definition of relevance in Rule 401, Joyner v. State, 1997. So just know I'm not ignoring you guys. Hey, Skinny, what's up? Paula, hello. Deanna, hi, how are you? KB's here. Perp, where you been? Skinny. Let me see who else. What's up, guys? I'm not ignoring you. Ja Rule, Dee Dee, Monday. I'm not ignoring you guys. Critter, I'm just trying to get through this so I can then talk to you guys. But so just know I'm not ignoring you. It's Dee Dee told me to ignore you if I am. Just kidding. Relevant evidence may be excluded if its probative value is outweighed by unfair prejudice, confusion of issues, or the potential to mislead the jury, even R 403, or by its failure to satisfy any other evidence rule in Indiana Evidence Rule 402. Third-party suspect evidence is excludable under a rule. Is that a word? Excludable? Doesn't sound right. Excludable. Excluded. Excludable. Ugh. I call shenanigans here. Excludable. Under Rule 403, unless the defendant shows some connection between the third party and the crimes. Appellee 505 referring to this as a widely accepted principle, citing Holmes, C. McIntyre precedence examples, upholding exclusions of alternate suspect evidence because it was speculative and inadmissible as hearsay. Tibbs v. State, 2016. Evidence that failed to establish any direct material connection between the third party and the murder properly excluded. The police investigated Holder and Westfall and lost all their fucking interviews. Yeah. And never found, they never found any evidence. Well, we'll never know, I guess, right? They probably said some real dumb shit. I bet Holder for sure. He probably said some real Elvis Fields. If he had those video interviews, the first few ones, I guarantee you that guy said some criminal. Excuse me, sorry. I had to clear my throat. I need to grab a drink, sorry. Like as if Elvis Fields didn't say a bunch of incriminating shit, right? Anyways, so the police investigated Holder and Westfall and never found any evidence connecting them. I gotta get past that. I read it again. I don't want to stop. Or any other alleged odinous conspirator to the murders of placing them at the High Bridge Trail that afternoon. And Allen's proffered evidence amounting largely to evidence that they were adherents of Odinism and that sticks placed on the girls' bodies were purportedly in configurations similar to runes on Holder's social media. Yeah, Ryan Winters, Your own fucking cop jumped out of his chair and bumped his head on the roof. He knocked out a tile above his desk and demanded Holman go back and look at Holder because he saw the fucking tattoo he drew on his hand or whatever. It was exactly like the real photos this Winters had seen. He was an ISP trooper cop or whatever. And he'd seen the real crime scene photos of Abby and knew that this guy was Logan's, the dead girl's boyfriend's father. And he fucking almost bumped his head and went back to tell Holman to go fucking relook at this guy after clearing him already on bullshit. They go back and talk to him. He's like, yeah, I walked through the woods and listened for the tree branches for Odin to speak to me through the tree branches. Oh, he's cleared. Falls for a short of creating a non-speculative connection to the crime scene. Holder had a confirmed alibi that made it impossible for him to have kidnapped or murdered the girl. Impossible. Fuck off. You could easily leave there, and I did it for 15 years at a work. I worked at a place where we could finish up after 6 hours. We'd finish 8 hours, or 8 hours. We'd finish 10 hours, and a bunch of us would leave, and 3 or 4 would leave, and one guy would stay, and we'd take turns swiping each other's cards out. And there were those little bank card. They weren't those big punch cards, and we didn't leave them at the punch clock. We put them in our wallets like little credit cards, and we swiped them in and out, these punch clocks. And that's what these guys are all doing. I fucking know it. So just because his truck is on video, whatever. Holder had a confirmed alibi that made it impossible for him to have kidnapped or murdered the girls shortly after 2 p.m. on February 13th, 2017. And it's footnote 31. Holder's son, who had been talking to Abby, also had a confirmed alibi. He was in school in Logansport that day. Yeah, Logan only seen her once. He met her. They met in earlier mid-December. And the first time they met face-to-face, which I get it, kids nowadays could have a relationship online, and being close in schools, they would know each other, whatever. So the first or second time they see each other in the park, Riley Park, whatever, was like 2 weeks before she goes missing. I dead. Yeah, nothing happening there, right? Opportunity is one logically essential type of evidence a defendant must produce in order to have any chance of admitting third-party suspect evidence. David McCord, but Perry Mason made it look so easy. The admissibility of evidence offered by a criminal defendant to suggest that someone else is guilty. Whatever this is, reference 1996 book or something. Explaining that if the crime occurred in Miami and evidence demonstrably showed the alternate suspect was in Seattle at the time, evidence regarding that suspect could not make it less likely that the defendant was the perpetrator. See Lush v. State in 2003. Third-party suspect evidence properly excluded because third party had no opportunity to commit crime. When he was interviewed by police on February 17th of 2017, Holder said, yeah, what did he say? Show us that video. Oh, you lost it. Fuckers. Motherfuckers. Yeah, this is their narrative of what they remember, he said. Our narrative, like Liggett had a narrative of what Bessie Blair said. They all have these narratives because Doolin had a narrative because he lost the tape and all his notes. Yeah. Perfect. Everyone's got a narrative of what the witness says. Never what the witness says themselves or suspect. Always the cop's narrative of what they remember being said. Because, oops, we lost our notes. We lost the recordings. We lost the audio recording. We lost the video recordings. Yeah. Holman, Richard Allen sat in my car, and I usually tape everyone, but I didn't tape him then, or I lost the tape. Fucking guys. Holder said he was at work on February 13th and then went to his gym in Logansport, where he lived. And you could just say you're checking in anywhere. You don't have to physically be there to say you're there. So he could be elsewhere and say he was at the gym and just do a fake check-in on Facebook. It wasn't GPS dependent. You didn't have to literally be there. You could just say, I'm here. So who knows? I guess I don't know if he was on camera or whatever. Who cares? where he lived. Holder worked at a landfill in Buffalo, Indiana. 32. Buffalo is located 25 miles from Delphi. It takes 30 to 35 minutes to drive from Buffalo to the High Bridge area of Delphi. His work records confirm that he was at work on February 13th from 4:55 to 2:45 a.m. That's another thing, because that was a weird time. Like 5 a.m. to 1 p.m. is 8 hours. So you saying he works 9 hours and 45 minutes? That's a weird time. Right? Because picture 4:55, say 5 a.m. That means you're there 5 minutes early. You punch in at 5 or whatever. You're starting at 5 a.m. This guy. So 5 a.m. to what? 1 p.m. is what? That's 5 hours to 1 p.m. That's an 8-hour shift, right? So then he stayed overtime or something. He stayed an hour and 45 minutes. It's just a weird time. Even if they docked a half an hour for his lunch, but they'd pay you for the breaks, whatever. It's a weird time, 2:45. And it's so perfect because, you know, it's such a perfect time, right? 2:45. It's just after everything kind of like done, or like 2:32, right? So I don't know, just too suspicious here. And his gym records showed that he checked in there at 4:08 p.m. on February 13th. The operations clerk for the landfill, the only person who could make changes to the electronic time record, confirmed that she had not changed Holder's record. And she confirmed that it would not be possible for him to be absent while his time card showed he was present. That's bullshit. Because all these jobs, if you have a group of 4 guys that do like a certain set jobs, if you guys work your ass off and get it done an hour early, or you can kind of cover, one guy can cover 2 positions, as long as the work gets done, they wouldn't even notice a guy taking off a half hour early or an hour early. In my opinion, all these places are unionized places, and they have a set amount of jobs, a quota or whatever. And if you get it done, they could give a shit what you do. For 15 years, we got 8 hours worth of work done in 6 hours. And we could fuck the dog for 2 hours. We could just drink beer in the parking lot on night shifts. As long as we got our quota done, they didn't care. Guys would go home. I'd be cutting my lawn with 2 hours left of my shift. And I'd come back the next morning, and my buddy would give me my card in the parking lot. We'd swipe in, and I would do it for his, you know, I would take turns. So it's such bullshit. Only a small number of people worked each shift. Yes. Yeah. And it's such specialized dumper equipment that nobody else could do this, right? Fuck off. And it would be immediately noticed. Yeah. If somebody was absent at the beginning of the shift, yes. But if you all showed up, you always take off early. This is such hogwash. I was mad at the defense for this, because they should have talked to regular people about this bullshit. And I would have told them, hey, yeah, you couldn't not show up at the beginning of the shift, but every 4 to 5 guys could take off at the end if you got your numbers done. Every day, they wouldn't care. If you got your quota done, they won't fucking care. Or if a stranger was there. The equipment ran continuously. And if one person ceased working, yes, it would affect the entire, yes. But again, if you got your quota done, that's the whole rub here. Somehow the state let them off. The defense let them off, and it's too easy, because nobody was implying that somebody didn't show up at the beginning of the shift or took off. You know, I would imply that if they had a group of 4 guys or 5 guys doing the same ritual, you know, every day, and they had to do like 100 truckloads or something, whatever they did, they would get it done in 6 hours or 7 hours, and a couple of them could take off, and one of them would stay behind and swipe their cards out. I guarantee it. They'd probably do it today. Specialized training was needed to operate the equipment, further precluding the possibility that a holder could have sent someone to take his place. No, this was never the implication. Of course, you couldn't have somebody take your place. Fucking God, how'd they let him off of this? Because Holder could not have committed the crimes. No evidence about his onanism or his social media could have any tendency to decrease the probability that Allen committed the crimes. See Moore v. State, 2023. Hearsay evidence of third-party confessions properly excluded because third party had established alibis. Without Holder, the theorized connection to Westfall necessarily fails. It was central tenet of Allen's ritual killing theory that the crimes were not committed by one person. He never contended below that Westfall committed the crimes by himself. Westfall's alibi that he was with his son that afternoon was corroborated by his son. Oh, the son corroborated for his fucking father. That Holder's ex-wife's statements that Holder said Westfall murdered Abby or was involved in the murders, statements Holder denied making, were inadmissible hearsay. Apart from that, Allen points to nothing other than the fact that Westfall was an odorist. At best, this is weak, speculative motive evidence predicated on a speculative and inaccurate reading of the crime scene. See McCord and Supra at whatever, surveying case law to conclude that weak motive evidence without more does not support admitting third-party suspect evidence. This speculative theorizing, lacking any admissible evidence directly connecting either man to the crimes, does not rise to the level of admissible third-party evidence. See Pelley in a bunch of numbers. Evidence about the victim's connection to money laundering bank in Florida, and hearsay statements about limousine with Florida license plate seen in an area properly excluded as too speculative. Smith v. State in 2001. Victims' threats to third parties proffered as third-party motive evidence, properly excluded. Cook v. State in 2000. Victims' prior work as confidential informant, proffered as evidence of third-party motive, properly excluded as mere speculation. McIntyre, something numbers, precedents or example, witness statements about suspicious cars in neighborhood, and hearsay threats against victims properly excluded as too speculative. Magaha v. State in 2010. Evidence about victims' drug dealer, Sam, properly excluded in absence of any evidence connecting Sam to the murder. C.J. Joyner, some numbers. When forensic evidence connected third party to scene and excluded defendant, it was error to exclude evidence that third party worked with and was having an affair with victim, was with victim on night of murder, was late to work the next day, and falsified time card to hide tardiness. But then Brad Holder also got fired for fucking his tardiness. But again, tardiness isn't the problem for me. Showing up and doing 8 hours worth of work in 6 or 7 hours, and 2 or 3 guys probably fucked off, like drinking beers and just leaving the bar, the strip joint, and then one guy sticks around and swipes their cards out and meets them there probably or whatever, and hands them all back their cards or something. B, harmless error. Any of these alleged errors, individually or collectively, is harmless given the powerful independent evidence of guilt. The timeline and eyewitnesses' evidence, including Allen's initial statements to police, creates an overwhelming certainty that Allen was Bridge Guy, thus the murderer. Allen admitted he parked near the Freedom Bridge entrance and began walking the trail about 1:30 p.m., which was corroborated by the surveillance video capturing a car matching the appearance of his Ford Focus driving toward the Freedom Bridge entrance at 1:27 p.m. Oh, the timestamp was off for 54 minutes, but hey, the FBI declared it's 1:27 p.m. So hey, must be, right? He admitted he was wearing a dark Carhartt jacket with a hood, blue jeans, either tennis shoes or work boots, and had a hat with him. Oh my God. He had a hat, and his car had 4 wheels on it. You could see the light through the wheels too, which matched the clothing worn by Bridge Guy. Allen identified himself as the man who walked past the Wilbur Voorhees group on the trail at 1:30 p.m. Wilbur and Voorhees both immediately recognized the picture of Bridge Guy as the man who had walked past them, despite the fact that they both described a completely different guy. And Voorhees, fucking Steve Mullen, went and talked to Voorhees on the 15th at her school. The chief of police, 2 days after her friend went missing, she was at the trails, Voorhees, right? 1 day after the bodies are found, the next day on the 15th, she's at school, in high school, a girl, and fucking the chief of police comes there, and she tells him exactly what she remembered the guy wearing. And black boots, black jeans, black jacket, squared off jaw with a fucking mask, so hair sticking out, just a completely different guy. She never said short. You know, the chief of police comes to your school 2 days after your friends are murdered, 1 day after the bodies are found. You walk past a guy in the middle of the day on a trail. You describe him exactly. And she did. Black boots, black jeans, everything exactly opposite of Bridge Guy. Alan also admitted that when he reached Highbridge, he walked out to the first platform and stayed there for a few minutes. Blair entered the trail at the Mears entrance at or just after 1:46, according to the adjusted time of the Harvester cameras that were off by 54 minutes, right? Right. And when she reached Highbridge, she saw a man on the platform who she immediately recognized as Bridge Guy. Neither Blair, Wilbur, nor Voorhees saw anyone else on the trail who could have been Bridge Guy or Alan. And Alan acknowledged seeing no one else who could have been Bridge Guy. They've repeated this a few times, but as she walked back toward the entrance, Blair passed Abby and Libby on their way to Highbridge. And by 2:13, which at one point was supposed to be 2:31, or no, 2:13 was the video, but the 2:31 was when they went down the hill or whatever, right? 2:30, yeah, because 2:32 is Weber going by. And then that Cecil guy, or whatever he said, he wrote it down wrong. He wrote down 2:13 accidentally. 2:13:55, and then turns around and says, "Ooh, I meant to write 2:31 was the Apple Health data of Libby's going down the hill. 55," and then he goes, "Oops, it was 51." So therefore, another distraction. The man Blair, Wilbur, and Voorhees saw, the man Alan had effectively identified himself as being, was following Abby and Libby across Highbridge and ordering them down the hill. Yeah, 2:32. 2:31 is what the guy that Cecil changed it back to because he accidentally wrote 2:13. By 2:32 p.m., Libby's phone had stopped moving, and by 3:11 p.m., Libby was not answering the phone when her father called, and she and Abby had failed to meet him when he arrived to pick them up. Shortly before 4 p.m., Carbaugh saw a man she recognized as Bridge Guy walking across on 300 North toward where Alan had admitted he had parked his car. His clothes were covered in mud and fresh blood splatter, giving Alan's admission placing him on the trail and on the Highbridge platform at the right times to be the man seen by Blair, Wilbur, and Voorhees. There is certainty that the man they saw was Bridge Guy, the absence of anyone else on the trail who could have been Alan or Bridge Guy, and the tight timeline this combined evidence created in connection to the abduction. Like if you just keeps repeating it over and over again, it's going to make it true, right? It's like the third time I read that paragraph. Different times. And murders. The only reasonable conclusion to be drawn was that Alan was Bridge Guy, the person who murdered Abby and Libby. Other evidence corroborated this conclusion. The .40 caliber cartridge found by the girls' bodies was forensically matched as a subjective bullshit opinion as having been cycled through Alan's .40 caliber handgun. Alan had an identical unfired cartridge, the only piece of Winchester ammunition found in his house, in a keepsake box. Fucking Alan had no possible innocent explanation, as if he needs one, for how a cartridge that had been in his gun could have ended up at the murder scene. Bridge Guy had a gun and used it to compel Abby and Libby to go down the hill. An ISP trooper who had listened over 700 of Alan's phone calls opined that it was Alan's voice heard on the video saying, down the hill. Although Alan had 12 old cell phones in his bedroom closet, he did not have the cell phone he had handed to Dan Doolin 3 or 4 days after all this in 2017. The one Dan Doolin held in his hand and took the battery off to write down the IMEID bullshit number or whatever. Police he had with him on the trail. 5 years later, he didn't have the phone that Doolin held in his hand. Damn him. Creating a reasonable inference that he destroyed the phone. Maybe Doolin destroyed it. He was holding it because his fingerprints were all over it. Because he knew it contained evidence of his guilt. Like, if Alan's guilty for this, what is Doolin? Oh my God. Alan also displayed consciousness of guilt by lying to police. Although he originally told police he was at the trail from 1:30 to 3:30 p.m. And the testimony of Wilbur and Voorhees proves that he was arriving at the trail, not leaving at 1:30 p.m. When the police re-interviewed him in October 2022, Alan claimed he was at the trail much earlier, from 12 p.m. to 1:30 p.m., showing he understood the damning implication of the initial timeline he had admitted. While police excluded the search warrant at his house, Alan said multiple times, "It's over." Alan confessed to killing Abby and Libby multiple times. He explained that he was frightened by a van driving past, causing him to abort the intended rapes and kill the girls. Yeah, he was so afraid he spent an hour and 15 minutes doing such unnecessary, meaningless tasks. Yeah, he was scared to spend an hour and 15 minutes. And then walk down the middle of the road during the daytime. A detail only the killer would know, that was corroborated by Weber's testimony, that he arrived home from work in his van shortly after the time the girls were forced down the hill. The evidence of guilt was conclusive and irrefutable. Moreover, as has been referenced throughout, Alan subjected the state's case to adversarial testing by presenting evidence of inconsistencies between eyewitnesses' description of Bridge Guy and Alan's appearance, and between eyewitnesses' descriptions of the car parked at the CPS and Alan's focus. I won't tell you what I rubbed my eye, and I think I got some, I don't know, felt like, I don't know. It's almost like my one eye just started watering. So I'm kind of reading with one eye. It's stuffy, but I got my window open. Whatever. I'm going to get through this. Look at it. I'm almost done. Expert testimony challenging the validity of the ballistics match the length of time Alan was held in restrictive housing, DOC policy on restrictive housing, and its effects on mental health. Like my left eye is stinging, and it's like pouring, like I'm crying in my left eye. I just poked, like I was rubbing it. It's like, I don't know, I got grease in my eye or something. I don't know. Expert and lay testimony regarding Alan's mental health at the time of the confessions, and video evidence of Alan's behaviors around the time of the confessions, and evidence that Libby's phone data showed a headphone connection in the audio output during the evening of the 13th that was not explained by the state's theory of the crimes. If those attacks failed to cause even one juror to have reasonable doubt, then this court can be confident that none of the comparatively insignificant pieces of excluded evidence complained about here would have made any difference into the verdict either. So then why would you just let them have it then? C. Admission of a possible explanation for a cell phone code was harmless. The admission of the Google search was at most harmless. Defense witness Stacey Eldris opined that between 5:45 p.m. and 10:32 p.m., Libby's cell phone registered a code in the Knowledge C database of an audio output start, which indicated that headphones or an aux cable was plugged into the phone. She opined that the event required human interaction, which Alan offered to suggest that someone else committed the murders, because Karboff saw him leave the scene by 4 p.m. Yeah. There was water and debris on the phone when it was found. To Eldridge's knowledge, yeah, Cecil went and Googled it, right? Water would not affect the plug-in data. The state's 2 cell phone experts, Christopher Cecil and Brian Bunner. So Cecil's out Googling shit and reading forums, iFixit forums for phones. It's a good place, but I mean, it's just all people in a forum, writing their own, regular guys like me, writing how to fix iPhones and stuff. And Brian Bunner, his whole thing was talking about the interpolation of the video and all that. And his presentation booklet, whatever, he cited stuff from 1989, which was like 32-bit, I don't know if it was film or what. It was like a little bit more than an Atari, but less than Commodore 64 or Nintendo 64. It was like 32-bit from 1989. And this Bunner guy in his thing, like, when there's citations and footnotes in his presentation, you would read it. He was referring to a book from 1989 of how he compared the interpolation footage and the frames of the video in 2017. And he was comparing it with 1989 and 1992 protocols. It was fucking amazing. Testified that they did not know what audio output start meant. Yeah. He was talking about fucking 32-bit stuff from 1989 and 91. On cross-examination, the state asked Cecil if he had done a Google search to determine if water damage could cause the output code. Allen unsuccessfully objected on hearsay grounds. Cecil testified that he found through that search that water damage or dirt within the headphone plug-in could cause the phone to register an audio output. Cecil acknowledged that he does not normally do Google research and that information on the internet can be wrong. Yeah, this information was proffered as an alternate theory of the cause of the audio output code, but neither of the theories made it more or less probable that Allen committed the murders. As argued above, his identity was proven through eyewitness testimony. Allen's statement to the police, the cartridge from his gun found between the bodies, and his confessions. The health app data showed the phone did not move after 2:32 p.m., defeating any suggestion that the phone was returned to the crime scene after 10:30 p.m., which in any event would not preclude Allen being the perpetrator. And any suggestion that another person was present at the murder scene at 5:45 p.m. and 10:32 p.m. during the height of the search for the girls. Nobody went across the other side of the creek. There could have been 10 people standing there. None of you cut across this creek or down the hill or from Ron's or the cemetery, that whole little area there. Flashlights wouldn't even work there, you said, right? Anyways, inserting unplugged headphones from the phone was implausible. This evidence had no bearing on the verdicts and was harmless error. 4. The trial court properly denied Allen's motion to correct error. The trial court properly denied Allen's motion to correct error because the state did not knowingly present false testimony through Weber in violation of NAPU v. Illinois in 1959. A conviction obtained through the use of evidence that the state knows is false and does not attempt to correct violates a defendant's 14th Amendment due process rights. NAPU, some more numbers, Smith v. State, Precedents 2015. To make a claim under NAPU, the defendant must establish that there was false testimony. The government knew or should have known it was false, and there is a reasonable likelihood that the false testimony affected the judgment of the fact finder. United States v. Freeman, 2011. Allen failed to show that the state presented false testimony through Weber. Allen's argument is predicated on surveillance video he claims shows Weber's van arriving home at 2:44 p.m. Yeah, it does. There's a video of it. But Allen did not present any verification that the date and time on that video was accurate. What? So they can use inaccurate timestamps and say that they're this time, yet when they're presented with a timestamp in a video, they say, ooh, your timestamp isn't even good enough. Imagine the defense said, oh, we think it's this time, and changed it even. Oh my God. Why the fucking, this is amazing. How do you win against somebody who can just say they have the FBI declare timestamps off? Liggett declared the timestamps off, and Logan dumped his white truck when he's dumping garbage. Liggett declared him off by 32 minutes or something like that. Like, how do you go up against that? They can change timestamps, and then when you present a video, they tell you your video timestamps aren't correct. Oh my God. But Alan did not present any verification of the date and times. Like, how do you verify it? Because you guys have the power. Like the FBI waves their pen. Ooh, I'm an FBI agent. I say that this Harvester video is off 54 minutes, and I signed this paper. Therefore, poof, now it is. The whole fucking, everyone's timeline is going to be off now. Wow. It is common for timestamps on surveillance videos to be inaccurate by minutes or hours. So then your evidence is garbage if it's off. Simple as that. Evidence is garbage if your timestamps aren't correct. For example, the Hoosier Harbor, 54 minutes, fast. No, it means it's garbage. You don't just get to fucking declare timestamps off. Allen admitted that the camera's timestamp was inaccurate as it showed bright daylight when the timestamp indicated the middle of the night. When was that said? Allen admitted the camera's timestamp was inaccurate as it showed bright daylight when the timestamp indicated the middle of the night. Oh, because that one that they said it was off by 12 hours or something. Yeah, I remember that one. I remember the one where Weber's van's driving by. Right. I'll look into it. I forget. There is no basis to assume, as Allen does in his argument, that the only inaccuracy was a precise 12-hour difference. Right. Yeah, that's what they said. And yours was off 54 minutes. If a time's going to be off, 12 hours is more believable than 54 minutes because these will be off exactly on the hour, not a couple of minutes, because they think they're in the wrong time zone, not the minutes, just on the hour. So I would believe 12 hours if the minutes were exact versus the 54 minutes they say that the Hoosier Harvester was off. So it's not like the old days when you unplug an old clock and it stops for 30 minutes, then you plug it back in, it's 30 minutes behind. No, they're off only by the hour, 2, 3, 4. They think they're in the other time zone, Central, Mountain, Eastern, Pacific, or that it was 12 hours slow rather than fast. Absent verification of date and time, and absent proof that the vehicle on the video is Weber's van, Allen cannot show that Weber's testimony that. So where's the verification that you say the Hoosier Harvester time is off? You did it. You said the Hoosier. Where's that verification? Because you're an FBI agent, you got superpowers. Weber's testimony that he drove straight home in his white van after clocking out of work at 2:02 p.m. was demonstrably false. Allen also offered no foundation to support the ping evidence in the FBI report. Yeah, there was 3 other phones or whatever within 100 feet of this fucking around the time this was happening. Unidentified phones in that circle around the same time, without any evidence as to who, whether, or when Weber had his cell phone turned on. The absence of a ping earlier, because when Weber drove into the area, his phone pinged off a tower, but it didn't ping. They're saying he was home at 2:30, and the ping wasn't until 2:45, as if he's home at 2:30 and his phone takes 15 minutes to ping. No, because he drove into the area at 2:45, and that was when the first ping happened. So that was, how do you fight people when they can just say your evidence? This is great evidence. They can just say, fuck it. Because it basically proves that Weber came home around 2:45 at the same time as they claimed in the video. Because his first ping, like a few minutes, he gets up his driveway, gets to his house, and it pinged But they say he was home at 2:30. So he was home for 15 minutes and it took that long for his phone to ping? Baloney. About paying earlier does not prove he was not home earlier. Yeah, it does to me. Allen did not show that Weber's testimony was demonstrably false in support of his NAPU claim. And Weber said a different thing to the FBI guy who couldn't come in Zoom testimony. Allen's claim also fails on the third step of the NAPU claim. Hey, unindicted. Peggy, what's up, guys? I'm going to just get through this. Let's do this. In this step, reviewing courts will consider, my nose is getting stuffy and I got my window open. Whether the defendant had an adequate opportunity to expose the false testimony on cross-examination. Freeman, bunch of numbers. The state had disclosed the surveillance video from Weber's neighbor and the FBI ping report to the defense prior to trial. Despite having the surveillance video at trial, Allen never asked Weber to identify his van on that video to expose his allegedly false testimony or even to impeach him. This was presumptively a matter of trial strategy. See Davis Martin v. State, 2019. Finding no NAPU violation when the defense had the police report and chose not to ask the witness about it. One sec. The crux of Allen's claim is that if Weber's testimony was false about his time of arrival home, then Allen's May 3rd, 2023 confession to F.G. Walla was not credible. Appellant's brief 103. This premise fails for two reasons. First, Weber did not testify to an exact time of arrival home. So Allen's evidence would not have shown that Weber's testimony was false, only at most inconsistent with the murder timeline. Appellant's brief 103. Second, the credibility of Allen's confessions was challenged with a plethora of expert evidence. The jury had ample evidence to evaluate not only Weber's credibility, but the credibility of Allen's confessions. Allen was not denied due process. See Stewart v. State, 243 Northeast, 2024, finding no violation of due process when the jury was able to evaluate the witness's testimony in light of inconsistencies and effectively act as a fact finder. This court, what's the trans denied? Whatever. This court, I've been avoiding that. So this court should affirm the denial of Allen's motion to correct error. The conclusion, the court should affirm the trial court's judgment. Respectfully submitted, Theodore, Alvin, and Simon Rokita. This one, Alan H. Mylander, Jody Catherine Stein. Oh, Todd Rokita again. Where's Nick? They counted the words. I verified. I counted the words. It's no more. Yes. So dumb. Mylander, she's the word counter. Oh my God, certificate of service. I certified March 22nd, 2026. The foregoing document was electronically filed using the Indiana e-filing system, IEFS, and that on the same date, the foregoing document also was served upon counsel via IEFS, addressed as follows: Mark Lehman, Stacy Uliana. I like that name, Uliana. And Lehman's the guy that was at the Supreme Court. He was really good. He did good at that contempt hearing bullshit, or the exculpatory evidence shit, or whatever. No, it was the contempt hearing stuff at the Supreme Court when he went up against Wheathead and him. And so Nick's name not on this. So maybe I read as Nick and it wasn't even Nick. No, it wasn't, right? So I'm an idiot. You guys fucked me up. I'm going to forget that. This isn't Nick. Who's doing the appeal stuff? Is Nick? I don't even care. Fuck it. It was fun. Anyways. Yes. Yeah, I think so, Peggy. I think so. You guys tricked me. You guys fucked me over. You guys fucked, because I wasn't doing it. So there. We'll always have the memories of that. I kind of let up. I did Nick. Started around the 15th page. So the first part. But yeah, I guess Nick. Who's the prosecuting guy? This is the state's response. Oh my God, I've been reading for 4 hours and 30 minutes. Get out. Get out. Did I start this and start reading this? 4 hours and 30 minutes? There's 33 people in chat? Oh my God, Peggy, you fuckers. Yeah, you laugh. Go ahead. Because I asked you all. Yes, sorry, TJ. Well, you got 4 hours. You can go back and listen to it. I read it perfectly. And I started reading the first 15 pages. I read it just as me, not thinking. And then I asked everyone in chat if this was Nick, and they're like, yeah, do the Nick voice. They peer pressure. They not bullied me. What is it when? I guess peer pressure. Yeah, I wanted to be cool for you guys, and I did the Nick voice. I kind of let up near the end, but whatever, because this isn't Nick, right? You fuckers. I'll have to read this again tonight as who is it? Ellen H. Mylander? So who was it? Nick's name's not on this at all. So he's the guy. So it's either this one or this one. Counts for the appellee. Yeah, it's going to be one of these two. Ellen or Jody. Fuck it. I think Ellen and Jody together sound like Nick. So fuck it. So what do you guys think? What do you guys think? We're going to go through this again, obviously, right? Everyone else is probably doing it. So what did you guys hear? I've been ignoring you in chat. So starting now, I'm reading chat. So what's up? Yes. Let's just forget about that, okay, Peggy? This right here. Did you just do this whole thing in McLean's voice for nothing? Well, I can go back, and my chat is on the screen. Good, it's on the screen. So I'll show all you guys saying, yeah, do it. The peer pressure from you guys, man, it's all your guys' fault because I asked you. Everyone's yes. So we're all in this together. So, anyways, you know what? Executive decision, because all the time I've been doing a reading for the last 3 or 4 months, anytime I did a prosecution person, I used that voice. So Pegs, right? We did all right. We did the right thing. Zibby, we did the right thing. Think about it. I'll check my Discord. Oh. No, it doesn't matter. But when you think about it, even if it's not Nick, I always would use the prosecution voice. So that was the standard prosecution voice. And you can go back and look at my last 3 months of reading everything Delphi. If it was anybody from the prosecution, they got Nick's voice. So I've made a decision that it's the right thing. Right. You wrote that, Peggy. At what time? 1:10 p.m. But you know what? I'm glad I didn't listen to you, Peggy, because now that I think about it, that is my standard prosecution voice. And you can go ask TJ, ask anybody. Go back and listen to any of the 300 hours I've read everything from this case. No, I'm not worried. I'm actually glad I didn't listen to you. And I know I did a great job. Thank you. But think about it. Because at first I thought, since it's not Nick, I screwed up. But now that I think about it, I've literally used that voice for Latrell, Diener, anybody from the prosecution side gets that voice, and they are from that side, right? And the defense side always got the nice Shibby voice, and law enforcement and Judge Gull always got the gruff voice. So now I'm glad I didn't listen to you. I'm glad I ignored you on Discord again. I might have to unfriend you now, like you did to me. I'm like kidding. So how about this? We'll finish this up. Do you guys want to talk about anything before I shut it down? There's probably 50 people talking about this, other channels and that. Dee Dee, What? I missed something? Oh, you know what you missed, Dee Dee? Well, remember in the beginning, I realized I should be doing Nick's voice, and I switched to Nick's voice. And then Peggy tried to remind me a couple hours ago that it's not Nick speaking, that it's these prosecution people. It's not Nick. So I thought I screwed up by doing Nick's voice, because it's either this Ellen or Jody on behalf of Rakita, like the prosecution, right? Because it's not Baldwin. It's Lehman and this is the appeal stuff, right? So it's one of these two. So I shouldn't have switched to Nick's name. I felt bad and felt dumb, but I've realized that you'll know it, Dee Dee. Every time I did a reading, anybody from the prosecution side got Nick's voice, and these would qualify. These would qualify, because if I was reading the court transcript, I'd go back and forth. All these prosecution people would get that shitty voice, and then the defense people and nice witnesses would get my good Shibby voice, and law enforcement and Gull would get the shitty gruff voice. So I'm glad I ignored Peggy again. I'm just kidding. So what do you guys want to talk about? I should probably shut this down because I need sleep. I've literally been up since, I don't remember when, yesterday. I've been up all night. All right. So do you guys want to cover anything, or do you guys want to just let me get some sleep and we'll do it tonight? You know what? I'll get Ted to do a live stream, and we'll do a big one with Ted, and we'll go over this again. Okay. How's that sound, guys? So someone summarized the false narrative. Well, yeah. Well, this is the appeal. This is the response to the appeal. So it's not that they're summarizing it. This is the response to the appell. This is the appellee. The appellant. The appellee brief is the state's response to the appellant brief, which is the appeal. So now whoever the judge is going to, I guess, take this both into consider, right? This is their argument back. Shibby, honey, please rest and yes, you're right. Unindicted, you're so right. Honey, love it. So how about this, guys? I'll shut her down. You guys find someone else if you're not going back to sleep like I am. I'm back to sleep. I'm going to sleep, and I'll get a couple good hours. And when Ted wants to go live, we'll do a dual stream, or I'll go on Ted's, or or Peggy can come on, or whatever you guys want to do. We'll definitely be covering this again tonight properly. And now that I've read it, we can stop and pick it apart. And you guys got time to go back and play this and listen to me or read it yourselves, okay? Should you have to join us at 7 p.m.? Oh, you think what time is it? No way I'll be up at 7 p.m. If I don't get at least 6 hours sleep, I'll be the biggest baby. Oh my God, it's 5, so I'll have to sleep till 11 p.m. I'm dead serious. I'll have to sleep till midnight. If I don't get at least 6 p.m., okay, I'll get 5 hours. And I mean, if I don't get 5 hours, I'll fucking be on a rampage, you guys. I'll be taking your wrenches and deleting you, hiding you forever. And I'm only kidding. Well, let's see. I'm gonna have a nap, and when I wake up, I'll set an alarm. I'll text Ted and see if he wants to go live later, whatever. This definitely is going to be covered again. So, and I'll come back on and do it myself too. Don't you worry. And TJ, if you're going live, I probably won't be able to make it if you're going live at 7 p.m. So I'll catch the replay. 10 p.m. is the earliest I can. It's 5 p.m. now. I literally have been up all night. Literally. Look at me. I did a whole live stream. Look at. I'll show you. I'll prove it. Check this shit out. And I just finished. I only did I took a couple hours off, and then this came out, right? And then I was like, what? I said, fuck it. I got to do it. I was about to go to sleep. I was like, I got to do it. For the people. But look at live. So here I am live now, right? I just did a whole live for 6 hours ago. I did 11 hours. I did a fucking 11 hours and 55 minutes 6 hours ago. And this live is 4 hours and it's almost 5 hours long. So I did 12. Look at that. So 6 hours ago, I finished 12-hour live. And now this live is almost 5 hours. So I took an hour and 15 minutes and started this one. You guys, I did fucking 11 hours and 55 minutes, 12 hours, just 6 hours ago I finished. That's crazy, you guys. Oh my God. And I stopped early because that last guy, I couldn't squeeze him in. And I was reaching the limit of 12 hours. So I had to stop. Fuck it. Fuck it. Okay, Paula, I'm going to sleep. Okay, guys? I'll see you tonight. If Ted goes live, I'll be there. Or I'll go live. Or if TJ, I'll catch your replay if you go at 7 or 8. If anything happens before 10 p.m. East time tonight, I probably won't be there. I can guarantee I won't be there. You might not see me again till tomorrow. If I'll try to come back tonight. We're going to cover this, okay? So thanks, guys. 31 people. I should keep going. You guys want to keep going? Oh my God, I gotta end it. 31 people. I never get this many people, but I'm going to shut it down because I'm going to leave you guys thirsting for more. That's it. I got to do the right thing. Here you go. I won't even play my, here, I'll put this one on for you guys. How's this? I'm going to remove this and have an outro of, this is a good outro. This one. Enjoy this, guys. I'm not going to loop it. I'm just going to play it once. It's a minute or two. I'll be back tonight for sure. So thank you. I definitely have to go to sleep. You're so right, sees through. Jer, you guys are great. Catch the replay if you missed it. And it wasn't a mistake. I did Nick's voice because that's anyone from the prosecution gets that awful voice. So I did the right thing and I ignored Peggy. I listened to Peggy at first and then I ignored Peggy. So I did the right thing. I listened to Peggy, then I ignored her. That's my new philosophy. Listen to Peggy, her first suggestion, and then ignore her everything else. All right, guys. Have a great day. I'll see you tonight for sure. We're going to do more of this. Go find some other people. Whoever's live now, enjoy yourselves. I will be back. 5 hours at least I need, okay? All right, guys. Thank you. Bye. Oh, leave comments or anything underneath if you want me to cover or do anything or find Ted's live. I'll be back. All right. Bye. Enjoy this.
Ladies, pop your pussy like this. Shake your body, don't stop, don't miss. All you ladies, pop your pussy like this. Shake your body, don't stop, don't miss. Just do it, 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 do it now. Lick it good, suck this just like you should. Right now, lick it good, suck this just like you should. My neck, my back, lick my pussy and my crack. My neck.
you just touched Christy Boris hoo-hoo.
Shibby!
Low five. Yeah.
Let's get out of here.